Boom. Hey, folks. It's a lovely day. I cannot express just how lovely today is because, holy crap, it is insanely sunny outside. I am kind of sweating. I've got some air conditioning inside, so that's a good thing because otherwise, me and the lights and all of that would be pretty miserable. Um, I'd be like, why am I not outside? Um, but and I got to hang out with you guys, and I've got a lovely beverage. This is a Moscow Mule in a can. Thankfully, they're decent Moscow Mules, so they are wonderful. Some people are saying, how was the picnic? Mrs. Runkle and I had a lovely picnic outside, just hanging out with the dogs in comfortable chairs. And yeah, somebody says, how often do I need to use the air conditioning? Not often. Occasionally, a couple months out of the year. That's about it. So yeah, now I am sorry for being behind on this one. I hope you'll forgive me. I was on Nicholas's stream as well as Friday Night Frenzy. Fridays are busy, and I feel like fighting Rob for viewers is probably just, I don't know. I'd rather be on and chat with just chat with Rob, and then but we'll cover sort of some of the stuff we talked about and some of the additional stuff. Ian, I can't believe you're in the heart of a Game 7 Stanley Cup final and completely indifferent about it. News to me. Game 7 is like whichever side wins goes forward. Is that how that works? It's been a while since I watched any hockey games. So, yeah. All right. Now, I guess I can share with you some other updates. I'm a little pissed off today, and it's not your fault, chat. It is nothing you guys did. It's the cup. Okay. Winner is the winner. Okay. So, let me explain why I'm a little bit pissed off. And again, it's nothing you guys did, but I'm just going to sort of share this with you guys. It is it's a little exceptional, and I'm sharing it with you guys for two reasons. One, so that I can tell you guys that this is the kind of poop that you should absolutely not handle. I mean that you need to stay away from, because this is dangerous poop. This is poop that could explode in your lives. But also because, because it's frustrating. This is a degree of poop that I am frustrated about. So, I mentioned that there's a guy, a vexatious litigant who apparently the police think wants to hurt or kill me. And he also filed an affidavit in court alleging that I am a danger to him somehow. And he provided some evidence about it. And one of those pieces of evidence is really beyond the pale. And, as I mentioned, I don't want you to reach out to this guy. I don't want you to talk about this guy. I don't want you to anything. Like, just leave this guy alone. But I just wanted to share with you why I'm a little bit annoyed. And that is this. So, this is with regards to a complaint, and it might be hard to read because it's a little pixelated, but it says, please see below, some followers and friends of Ian Runkle are planning to murder me. That was from Mr. Tcan. And it says on his X website, they're discussing to murder me. This is apparently the only person on the planet who calls it X, but, I want to read to you. I know you guys can't really read it. I want to read to you what And this is literally somebody who's in my chat right now. This is Nanner. Hi, Nanner. He's talking about you. He's quoting you. Nanner, I don't think, is a danger to anybody, but I want to read to you what the supposed plan to murder is. I'm quoting, I'm sure by now 1 million people have told you, check out Pixie's or Corey's channel about his headstone. So, yeah. This is clearly not about Mr. Tecan, right? This is obviously not about Mr. Tecan. This is about Captain Corey, and specifically about the headstone for Captain Corey. I am pissed off because that's freaking gross. Somebody's saying I don't understand. Okay, I'll give you guys the background. After or during, I forget the timing, the Johnny Depp trial, Captain Corey is a child who had progressive health issues, and they resulted in him needing to get a heart transplant twice. And then he began experiencing heart failure a third time. And he made a very difficult decision, which is that he decided he couldn't go through that a third time, and that he was just going to basically take his chances, but he knew that he knew where that would lead, which was that that heart failure would inevitably kill him. So he went on the Make-A-Wish list, and Johnny Depp, he wanted to hit 100,000 subscribers, and Johnny Depp sort of gave a shout out to him to help try to make that happen. And a bunch of us, myself included, but I'm not claiming credit here, Rob, lots and lots of people were talking about, like, let's get Captain Corey to 100,000 subscribers. And we did. And now Captain Corey, he was posting online. He had a wish list. And you think, oh, his wish list is just going to be stuff for him. And that's not how he was. He had stuff on his wish list because he was donating stuff to local schools. He was really working towards charitable endeavors. And then ultimately he passed, and a bunch of us, myself included, helped raise money for his service. And that's what this is about. This is about the headstone for a heroic child. That's a thing. So, obviously this has nothing to do with anyone in my community intending harm to Mr. Tecan. Mr. Tecan, if you're watching this, do better. You do seem to obsessively follow my stuff, so do better. But yeah, nobody cares about you, Mr. Tecan. We care about Corey. And, it's really, really odious to take a statement of love and caring and try to turn it into something like that. So, if I'm a little salty today, if I'm a little annoyed today, just kind of laying that out there, just kind of explaining, because, I'm going to have some thoughts on that when I get to court filings, because going to address that in a big way. All right, people are asking for the Corey swoop. We will do the Corey swoop, and then we'll move on and talk about this trial, which is completely a different thing. But All right. I guess here we go. We'll see. All right. That one still kind of gets me. Okay, so let's talk about what happened on this this occasion, because day 29 of the Karen Reid trial is the continuation of the medical examiner, because they had the medical examiner at the beginning, and now is the follow-up to the medical examiner. And so after the medical examiner is done her direct, there is the cross-examination. Now, I'm just going to say this is a really interesting cross-exam, because a lot of cross-examinations are ones where you're trying to elicit information from somebody who doesn't want to tell you the information. But here, this is a witness who isn't hostile. She's not against the defense in the same way that the police officers were. She's just there to tell her side of things, and a lot of her side of things is just basically, hey, I just want to, and I'm just thinking, I know Tican's going to take that out of context when he next, does does some court filings about this. He's going to take some of those comments out of context, because that's just what I expect. So, yeah. All right. Anyway, the medical examiner here issued statements basically to say, hey, the cause of death is undetermined. And we saw that Trooper Proctor said that she was a whack job, apparently. And so let's see. You could tell me if you think she's a whack job. Certainly some of the people on Twitter who have taken strong positions about this have decided that she is. That's what they've said. So, yeah. Nanners, I also just want to note, you did not do anything wrong there. I just want to make that clear. 100%, there's nothing wrong with what you said. I really appreciated you sort of helping make sure that I knew about it. I did get a million messages, but I appreciated every one of them, because they were all coming from a position of caring. All right, so let us do this. I'm going to put it like that so that I can still pull up messages, and yeah. Okay, let's I'll move if I have to. All right, let's just roll on. Can you guys hear the audio? Because I messed with it. There were some people who had issues with like the audio, so I tried messing around with it. Hopefully you guys can hear it. So yeah.
Whenever you're ready, Mr. Lally. Good morning, doctor.
Good morning.
Good morning.
Oh, wait, we got to change this. I was watching at 2x speed. You don't want that. We're going to watch this at, yeah. Yes, he did. He passed. So, yeah.
Some questions, just turning back a little bit from what you were testifying to about yesterday. You had mentioned in your testimony yesterday that you had received some, in addition to the internal and external examination that you conducted with Mr. O'Keefe, you would receive some other material that you had reviewed, correct?
Correct.
Now, included within that material was some material from the state police as far as the investigative agency investigating Mr. O'Keefe's death.
Correct.
Now, is that is that typical? Is that abnormal? If you could describe sort of in general terms, as far as what, if any, communication would you typically have with the investigating body or agency in relation to any sort of autopsy or examination you do?
Yes. In Massachusetts, under Massachusetts law, the medical examiner's office is responsible, and our role is to determine the cause and manner of death by doing an autopsy.
So basically, she is the she's critical for, she's got to determine cause of death. Okay, we're going to move on a little bit because I want to call attention to something that Lally was doing a lot during his directs. He also does it a lot, just generally. So let's have a look at this.
As the diagnosis of hypothermia and trying to sort of better understand the circumstances.
Objection, Your Honor. Sustained.
Have with the investigating body or agency in relation to any sort of autopsy or examination you do.
Yes. In Massachusetts, under Massachusetts law, the medical examiner's office is responsible, and our role is to determine the cause and manner of death by doing an autopsy. The scene, or the scene of death, or the place where the decedent is found, is controlled by the district attorney's office, and state police will do an investigation. When we accept a case into our office, we request reports, police reports, to explain and describe the circumstances of the death. It could be a house, it could be somewhere else, it could be outside. Every case comes with a police report, and we review that police report, and if we feel that we need more information, then we contact the investigating body and ask for more information, again, depending on the case.
And specifically in this case, in regard to Mr. O'Keefe, did you reach out to get some more information?
I did reach out, yes.
Was that in part in relation to what you were talking about in your testimony yesterday, as far as the diagnosis of hypothermia and trying to sort of better understand the circumstances?
Objection, Your Honor. Sustained.
All right, so let's look at that again. This is what I'm pointing to.
Mr. O'Keefe, did you reach out to get some more information?
I did reach out, yes.
Was that in part in relation to what you were talking about in your testimony yesterday, as far as the diagnosis of hypothermia and trying to sort of better understand the circumstances?
Objection, Your Honor. Sustained.
Why did you reach out?
I reached out because when the case was presented to us, and after I did the autopsy, I did not have all the information that I needed in order to certify the manner. The cause of death to me was I was able to determine the cause of death from the autopsy. When an event is unwitnessed, we usually reach out to the investigating agency and ask them whether they have any more information than they did on the day that the autopsy was done, because investigations sometimes take some time. So in the days and the weeks following the autopsy, I reached out and asked if there was any more information than what I was originally presented with. Was there any video from the surrounding areas? Did anybody come forward to say that they actually witnessed whatever happened? Again, by the time I was ready to finalize the case, and we have approximately 3 months or 90 days from the day of the autopsy until we issue a report, I was not provided with enough information for me to be able to determine the manner.
Now, Doctor, do you recall specifically who it was that you spoke with from the state police?
Yes, I documented that I spoke with Trooper Proctor, I believe, twice.
And with reference, not asking you anything as far as what that conversation consisted of, but as far as the tone of that conversation, did you feel pressured or coerced to come up with a certain determination?
No, I did not.
And
okay, so that was there's that comment about, did you feel pressured or coerced to come out with that determination? That was a very careful careful thing there. So
as far as the tone of
that I spoke with Trooper Proctor, I believe, twice.
And with reference, not asking you anything as far as what that conversation consisted of, but as far as the tone of that conversation, did you feel pressured or coerced to come up with a certain determination?
No, I did not.
And even if you had been, what would your response have been in reference to that?
My response was that I am responsible for what goes on the death certificate, and unless I have enough information, clear and convincing evidence, I cannot determine a manner.
May I approach?
Yes.
Ah, that opened in the wrong window. My attention is running wild here on me, but basically, Lally is getting ahead of a line of questioning, and Lally actually did a really good job getting ahead of that. And what I mean by a really good job getting ahead of that is that the way it was answered in combination with the specific shape of the questions, and the shape, like the way he asked the questions, was a very specific, specific thing. So, yeah, the issue on that is that Lally asks her basically, were you pressured in coming to your determination? And her determination was that it was an undetermined cause of death, right? So she wasn't pressured in coming to that determination. The issue was she pressured in terms of coming to a different one? So, yeah, I don't think she was pressured for coming to a different cause of death. She was pressured. The suggestion was that she was pressured to come to a homicide determination rather than an undetermined one. Nobody was pressuring her to come to an undetermined cause of death. So it was a very careful question, but you don't actually see this explored any further. All right, now I got to cover a couple of things here. First of all, Chelsea Rama says, here's a super chat if you'd like to donate to a charity in Captain Corey's honor. Hang in there against the man you don't know and have never met. Well, thank you so much. I will I'll send that off a bit later here. I posted a link to the Captain Corey Foundation fundraiser, which I think is still ongoing. Basically, they are trying to set up a foundation in Corey's honor in order to basically do charitable stuff. So thank you, Chelsea Rama, and I'll pass that along, but I pinned that so that people could know where to find that. And then what, if any, side quest are we sort of on? Taking someone's comment about the gravesite of a child and using it for pathetic, ignorant, and vexatious pettiness is beyond disgusting. Raising one up in honor of the captain. Thank you so much. Yeah, I was annoyed. I will address this. Alice Bowie, the Canadian Human Rights Tribunal is insane. I can virtually guarantee that the articles that you've read about that decision are wrong, because they are incorrectly reporting what happened. And so I'm debating whether I want to cover it, because it's going to be super angry people in it. But I'd recommend reading the actual case decision. It's on Canley if you want. All right. So, do I think the O'Keefe family are changing their mind about her guilt? I don't know. And honestly, I don't want to speculate about their thoughts. I don't think the GoFundMe link got pinned. It should be. I saw it. I see it pinned. I see it as the pinned link. So, yeah. All right. Let us continue on here. So, we're going to jump to
that is adjacent to it.
Thank you. I'm just going to need to take that. And Dr. we could have the lights. Thanks. Now, Doctor, with reference to what you were testifying yesterday as far as the subscapular bleeding, bleeding under the scalp.
By the way, I'm just going to comment. I'm going to give Court TV some props here because Court TV is noting, like, listen, there are graphic autopsy photos that are being shown, and they're not being shown on Court TV because Court TV is making the decision. I don't know if they were court ordered or if they just made this decision on their own. I'm going to give them the props either way. They're not showing any autopsy photos, and that is good because we don't need to see that. But you should consider that the jury today is seeing graphic autopsy photos, and some of those photos can be really gross because you know, for instance, they'll do things like remove the brain in order to have a look like the previous brain expert. When she says that she was looking for, you know, subarachnoid hemorrhages, the way they look at that is they dissect the brain, right? So, yeah, I'm going to talk a little bit about the strategy that that was employed as well by Lally, because some people have said that Lally calling the medical examiner last is stupid. I think, given his case, it's actually a bit of genius, and we'll talk about that sort of at the right moment there. I don't know if that's it, but I'm going to bring this one up. Ian, I spent my day binging your awesomeness. What your goals are for your channel are inspiring. Your true heart is visible to the world. Love being a member. Sending you so much love and light. Thank you so much. So, okay, let's keep going here.
Was that more or less prominent on one side versus the other side of Mr. O'Keefe's scalp?
Yes, it was more prominent under that laceration that
Not
we just
right
looked at.
now. My skull is kind of buried
So
under
more
stuff.
prominent on the right side, is that correct?
Yes.
Oh, and there's one I wanted to...
You testified yesterday about a blunt object injury in relation to the injury to the back of the head, then leading to the fractures and the bleeding in the brain, correct?
Correct.
And then further leading to the ecchymosis, is that correct?
In the eyes, yes.
Now that blunt...
The ecchymosis is what they're talking about, is like the raccoon eyes, which most people would just call, you know, black eyes, right? John O'Keefe had really serious black eyes because that's kind of one of the things that happens when you suffer serious, you know, serious brain injury. So it is what it is.
Objects. What, if anything, can you say about what that blunt object could be?
It could be any blunt object.
Now, from your training experience with reference to the number of autopsies and examinations that you've conducted over the years, would that blunt object possibility include the ground, especially if it was frozen ground?
Objection. Ask the question differently.
The injuries that you observed to the back of Mr. O'Keefe's head, skull fracture, would that be consistent with a fall to the ground?
It could be.
Would that be consistent with being projected by an object?
So, looking here at, you know, Lally is now presenting the possibilities, right? And so I'm just going to take this down to 1 speed. You know, she says it could be consistent with being struck with a blunt object.
That you observed to the back of Mr. O'Keefe's head, skull fracture, would that be consistent with a fall to the ground?
It could be.
Would that be consistent with being projected by an object, say in a pedestrian collision, and then striking your head on the ground?
It's possible.
Okay, let's watch that again. Let's watch this again.
That you observed to to the back of Mr. O'Keefe's head, skull fracture, would that be consistent with a fall to the ground?
It could be.
Would that be consistent with being projected by an object, say in a pedestrian collision, and then striking your head on the ground?
It's possible.
That's the prosecution's theory, right? That's the central theory of their case, right? Their theory here is that is exactly what he said, right? And then he, what was the response that he gets to presenting his critical theory to the ME?
Would that be consistent with being projected by an object, say in a pedestrian collision, and then striking your head on the ground?
It's possible.
It's possible. Like, she does not look convinced at all. She's like, it's possible. She doesn't say it's impossible. It's possible, but she certainly doesn't sound like she's thinking that it's likely or that she thinks it's beyond a reasonable doubt. If I'm on the jury and I see her go, it's possible, I'm going, man, what? What? Now, keep in mind, they changed up this courtroom. Like, they moved this to a smaller, tighter courtroom because the defense really wanted the jury to be able to see facial expressions. They picked a courtroom that was super confined because it would allow for the jury to see that, right? So that I think is a big deal. So yeah.
The arm injuries that you observed, would those be consistent with scratches from either glass or a piece of plastic or a piece of metal?
It's possible.
And the injuries that you observed, would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no.
Whoa. This is like, holy shit, what's happening here?
That you observed, would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no.
Is that consistent with a pedestrian collision? And she's like, they're not the classic injuries. No. Lally, this is your case. This is your case. And she's going, no to that? Holy crap. This is beyond bizarre that we have that, right? That is just beyond bizarre. So I've never seen that where I've never seen this where a prosecution witness, the expert to establish cause of death, is basically pouring cold water on the prosecution's theory of how John O'Keefe died. Holy shit. And when she says it's possible, she's giving every nonverbal hint that she can to say, I don't think it's likely, right? She's fantastic for the defense. If you're wondering why all the like Karen Reed is guilty like crowd, and I don't mean the people who are like, I don't mean the people who just hold that view, right? Because it's fine to hold that view. It's fine to take that view. But there are some people who take it to like a religious level where they're just like arguing, you know, and they're like fighting with everybody who disagrees. And they are angry at her. They're furious at her. And I'm going, this is a prosecution witness. Why are you guys angry at a prosecution witness and not thinking maybe there's a problem with the case? And yeah, the chat AI is on drunk. Go home, AI. You're drunk.
And to that point, as far as when you say classic, as far as a pedestrian collision is concerned, you've conducted autopsies on a number of different pedestrian collisions over the course of your career. Is that correct?
Yes, I have.
Do they all sort of mirror each other? Is there sort of a disparity depending on how the person interacted with the car?
Projection. Sustained. Watch the form, Mr. Lally.
He does this a lot where he leads really heavily. And then once he gets the objection, he just asks the open-ended version. And there's no hesitation. It's just, it seems like he's just doing it to lead his witness without sort of leading. I find it really a problem, and there's a point where if I was the judge, it'd be issuing an instruction. So, yeah.
What, if anything, are every injuries from a pedestrian collision the same?
No.
And why not?
It depends on many factors.
That's a very careful question. Like, are every injury from a pedestrian collision the same? Obviously not, because otherwise we just have the same outcome in like literally every pedestrian collision. Obviously it matters. Like, were you hit by a tank going, 100 miles an hour, or were you hit by a smart car going 5 kilometers an hour? Those are non-freedom units, but you probably get the idea. There's gonna be a difference as to, so yeah, I mean, I get the question, but it's obviously that there's going to be differences between different car accidents with pedestrians because they're not all the same car accident. But that doesn't mean you're not gonna see different patterns, right? Like, it's very unlikely, for example, that a car accident causes you to like die of cancer. It's very unlikely that a car accident inflicts dog bites. It's unlikely that being struck in the front by a car is going to leave burn marks on your back or something like that, right? So, yeah.
It depends on the position of the body, of the pedestrian or the person being struck. It depends on whether they are moving or standing still. It depends on the speed of the car. It depends on whether brakes were applied or not. There's a lot of factors that come into play.
Would another factor be sort of the shape of the vehicle that strikes a pedestrian?
That's also possible. Yes, that's a factor.
Now, I mean, you can kind of do the math on that one as to whether the shape of the vehicle is going to matter. Like, if we can just consider something that is really kind of ridiculous as a hypothetical for shape of the vehicle, let's consider a vehicle that at the front, instead of coming to a bumper, comes to a great big blade, right? And if that great big blade truck, for I don't know why you'd make such a thing, but Like, let's say you make a big blade truck, and that hits you at 100 miles an hour, then you're probably going to get a very different thing than if you get hit by, say, the Oscar Mayer mobile, the Oscar Mayer Wiener mobile. A Cybertruck kind of does seem to have a blade front, like a snowplow, I guess. Yeah, like a snowplow. So, all different things. All right, so let's keep going here.
And did you have occasion to see any photographs, or have you seen any photographs?
My mind
in
is a
relation
terrifying
to
place.
The defendant's vehicle in this case?
I have seen photographs, yes.
And the size or shape of that vehicle, what, if any, significance did that have to you as far as your examination?
Objection. I'll allow it.
When we have a potential vehicle, clearly we look at the height, because one of the things that we do in most or all pedestrian or people struck by a motor vehicle is look at the legs, because in the majority we see injuries to the legs from the bumper of.
You see how she's not saying quite she's not saying quite that the prosecution's theory is bullshit. She never quite goes there, but she says we would usually see injuries to the legs, right? Usually see injuries to the legs. You know what we don't have in this case? Injuries to the legs.
The car, again, depending on the kind of car, the size of the car, and the height of the bumper. So in Mr. Keefe, I did not see any injuries in the lower extremities. And looking at the car, I did note that it was a much bigger car with much higher, I would say much higher tail light, bumper. It was not a sedan or a car that's low to the ground where the bumper would be at the level of, let's say, the knee, or slightly above or slightly below.
And again, I believe yesterday in your testimony, you indicated that the skull is a
There was that big long pause, and that's because Lally did not like that answer.
pretty thick bone. Is that correct?
Yes.
Sustained.
With regards to the thickness of the skull bone, what, if any, significance, or what, if any, what, if anything, you say as far as the type or amount of force that would be would be necessary to cause the fracture that you observed?
Objection. Overruled.
I would consider the amount of force to be significant, again, without being able to quantify it.
Can I have a moment, John?
Yes.
All right, so he needs a moment. We're going to skip ahead to is this Action Jackson? Sorry, I didn't take a timestamp. I just had beginning of cross.
Would you agree that John O'Keefe's injury?
All right, this might be beginning of cross. Oh, not Jackson. It's Little. Right, I forgot.
Would you agree that John O'Keefe's injuries to his arm, let's start there, are inconsistent with having been struck by a vehicle at 24 miles per hour and then causing him to spin around and be projected 30 feet?
Okay, so you need to break it down.
Would you agree that John O'Keefe's injury to his arm are inconsistent with having been struck by a vehicle at 24 miles per hour?
I don't know. I am not a reconstruction expert. I'm not a biomechanics expert.
Hint, hint. Ask the biomechanics expert. Hint, hint.
Never personally inspected the car, so I can't offer an opinion on that.
You did examine John O'Keefe's arm, correct?
Yes,
You observed no significant bruising,
correct,
no fractures,
correct,
and no broken bones.
correct.
Now, keep in mind, the car is supposed to be, or the arm is supposed to be the primary point of impact with this side of this car. And there's no bruising, there's no broken bones. What? Ooh, what? Now I see somebody saying that they should have used, had Jackson or Yannetti cross-examine. I don't think so. I think that Little was the perfect cross-examination lawyer for this. She's got a very soft style. She's got a very gentle style, and I think that's exactly what you need for this particular witness. The other thing is I promised I would talk a little bit about, I said I would talk a little bit about the tactics of making this decision. So, or the decision to call her last. So there's two reasons why that is helpful to, and I can't say that I'm necessarily in Lally's head, but there's two reasons why this is helpful to Lally. One, they get to end off with the gross pictures, right? They get to end off with, here are the horrific pictures of the death. And against the tide, I see somebody's asking for the Zazzle link. Can you drop the Zazzle link if you could? So they get to end with that. But the other thing is that she's actually awful for the Commonwealth. And in order to convict, you basically have to have already decided that she is, you have to have already decided that this is definitely a homicide and that she's definitely been run over. Because if you're relying on the ME to tell you that it's a homicide and that she was run over, the ME doesn't tell you that. The ME actually says, not so much, maybe, but probably not. So I think burying her at the end has some good tactical sense, because for Lally, he's basically hoping that the jury is already convinced as to the cause of death, and that when she says, well, it's not the classic pedestrian injury, that they're going, oh, she doesn't know what she's talking about. We've already decided that she was run over, or that John O'Keefe was run over by, by this. So, yeah.
I'd like to talk about the injuries to John O'Keefe's face. You testified that Mr. O'Keefe had a laceration on his right upper eyelid.
Correct.
You also described multiple abrasions on his nose.
2, yes.
Although these injuries may not have been the ultimate cause of his death, you'd agree that less severe injuries can still be very important in interpreting the manner or the context in which that person died, correct?
Correct.
Okay, so this is important, right? Let's give an example of, I'm going to embiggen myself here just to give the example. Let's give an example of a situation where a minor injury can be a tremendous, a tremendous sign of a cause of death. So let's imagine that a person, male or female, doesn't matter, is found dead in their pool. Cause of death, drowning, right? And so they they run blood alcohol. The person is fairly drunk, but not super drunk, and no other drugs in their system. There's no head injuries. There's no other injuries except a couple of minor marks on their wrists and their ankles. And so initially you might say, okay, drowning, the guy's in the pool, the guy's fairly drunk. Maybe the person just drowned in the pool. It happens. People drown in pools all the time. But I want to ask you, do you change your mind about the drowning in pool if I tell you that those minor injuries to the wrists and ankles are heavily indicative of handcuffs? Does that change your mind about the cause of drowning in that pool? I'm going to guess that you would say, I have just gone from accident to murder in a real quick time if you thought that the person was in their pool wearing handcuffs, and especially if they weren't wearing handcuffs when they were found, right? That little minor injury, the little tiny marks on their wrists and ankles would be like, holy shit, this is huge, right? This is a really big thing. Now, I just want to let you know, it might not be determinative, because maybe the guy drowned in the pool because was thrown into the pool cuffed. But maybe the guy had a young woman over and they engaged in some activities a little bit before that, and then he decided to go have a swim afterwards, right? Like, it's not determinative, but it's really important to deal with those injuries as to what, what happened here. So that'll be a critical issue regardless of what the ultimate determination is, right? So obviously the ME is going to agree that small injuries can be a huge factor. I can tell you that the difference between there's certain kinds of injuries that are commonly seen in, that indicate something wasn't a self-unaliving, but was in fact a, that was in fact a homicide. You can have situations like, maybe there's a tiny little puncture wound. You've got somebody who's found dead of an apparent overdose, but you also find a puncture wound somewhere else. Does that raise questions? You bet it does, right? All of these are what the hell, right? All of these are, are interesting possibilities. So of course the ME is going to agree with this.
And in furtherance of that, you've been taught that when doing an autopsy, details matter,
Correct.
no matter how small.
Correct.
And that's one of the reasons as a medical examiner, you have to notate every single injury you find on a person. Is that
Correct.
And I can tell you, MEs go through a lot of detail. They'll go over the body and they'll look at every part of skin to be like, hey, is there an injury here that we weren't expecting, right? Is there an injury that we need to explain? And I mean, it could be that you've got, an injury that has nothing to do with the actual death, right? Lots of people have injuries at the time they die that have nothing at all to do with their death, right? I might have, you might burn your hand on the stove and then 3 days later you get murdered. The burn has nothing to do with your death, but they still are going to note burn on hand. How did that happen? When did that happen? Why did that happen? Was that related? Was that unrelated? And only when it's, and all of these things can be the basis of charges or the basis of an acquittal. Thank you for the kids saying to the dude who wants to do Runkle harm. You don't even go here. Stop trying to make fetch happen. Corey loved Runkle and made a video about his leather play button that literally still hangs on his YouTube studio wall. Do your homework, bro. Oh, I'm gonna be detailing that in an affidavit. Yep.
If I could show you.
Yeah, this is kind of a sad example, especially in cases of child abuse. They show older injuries. You'll sometimes see cases where like a child has died in something that is like, this is an accident, like the child fell down the stairs. And then when they go and actually like they do an autopsy of the child, they find all sorts of other injuries, like old injuries and so forth. And I can guarantee you that parent is going to get heavily questioned by the police going, hey, like, we got some thoughts here.
May I approach, Your Honor?
Yes. Show Mr. Lally.
Do you recognize that photograph?
I do.
And is that a photograph that was taken in connection with your autopsy?
Yes, it was taken at the time of autopsy after the face was cleaned.
Move to admit.
I'm sorry, after what?
The face was cleaned up.
Okay.
I move to admit.
If you're wondering why they wash you after death when they're doing an autopsy, it's because blood gets everywhere and can hide injuries, right? So, yeah, Bev is surprisingly sweet to Ms. Little. She's like, show Mr. Lally. She was actually being quite nice on that one. So, yeah.
Your Honor?
Any objection, Mr. Lally?
No, Your Honor.
Okay.
Exhibit 650.
All right, we're gonna jump ahead a little bit here.
You described the open wound to the back of his head as a laceration, which is sort of a blunt force injury that's not the result of sharp force trauma. Is that right?
Yes.
And you'd agree that Mr. O'Keefe's head injury came from some sort of blow to the back of the head, whether it be an object or the ground. Is that
Yeah.
right?
Yes.
Objection.
And that injury could be the result of falling backward from a standing position onto concrete.
It's possible.
It could also be the result of being struck with a large object such as
I'm just going to note that it's possible about falling backwards onto concrete was a lot more confident than was her, response about could this be from a pedestrian motor vehicle accident. We do not wear the powdered wigs, and no, I've never worn one. So, yeah.
a baseball bat or a barbell.
Me too,
Possible.
Jeff Carey, but I'm not
In
going to
other
spell
words,
it out.
it was an irregular laceration that resulted from some blunt force trauma.
Correct.
I'd like to sort of circle back to those injuries to Mr. O'Keefe's arm. You testified that there were, again, no fractures, no broken bones, no significant contusions.
Correct.
But you did describe the wounds to Mr. O'Keefe's arm as having discrete linear abrasions, which were caused by some sort of blunt object, correct?
Yes.
What does
Those are those like scratch marks or claw marks or fang marks, or everyone's disagreeing as to what they are. That's what those are. So that's what she's talking about.
discrete mean?
It means each one is an individual injury as opposed to confluent where it would be all meshed together.
Your Honor, if I could publish what's been previously marked as Exhibit 19.
Okay.
And these are sort of the linear wounds that you're referring to.
Yes.
And you testified that these also sort of appear in clusters or groups. You
Yes.
call them pattern abrasions. Is that right?
Yes, I did.
In some ways, they're really similar.
And you'd
Some
agree that,
places
for
they're
example,
different.
road rash does not result in this type of discrete linear wounds.
It could, but not exactly like this.
Road rash does not result in this kind of discrete linear wound. And she says it could, but not exactly like this, which is like, okay, theoretically possible, no.
Well, typically road rash covers sort of a large area of the skin. It would be a large abrasion. I mean, you've seen numerous cases of road rash in your
Yes.
career. And it doesn't look like that.
Correct.
Blunt force trauma can include injuries from various objects, as you testified, including an animal claw, correct?
So she says
Correct.
this is not road rash.
And you'd agree that these discrete linear abrasions are inconsistent with having been struck by a smooth rear tail light at 24 miles per hour.
Objection.
Too many moving parts to that question.
Can you answer that, doctor?
I can't. By a
Okay.
smooth, no.
All right, next question.
Now, she says, I can't. By a smooth? No. That sounded to me like it was a question, like it was an answer. And I would have followed up with, I just want to clarify, was that answer no, it wasn't possible, or no, you couldn't answer? I think this was a missed opportunity.
By a smooth rear tail light, you said that is not what you would see at 24 miles per hour, correct?
Oh, there's,
Sustained.
and then it's sustained. It's like, oh, why? She needed to ask it as the clarification question, not as the re-asking question.
As you testified earlier, you've indicated that based on the facts that were presented to you, you don't know what caused those significant scratches on Mr. O'Keefe's right arm.
I do not.
Oh, I agree.
May I approach, Your Honor?
Sure.
She's actually got 8 years under her belt, so she's not a novice. She's got some background on that. All right, let's jump ahead to hereabouts.
You testified that Mr. O'Keefe had multiple fractures to his skull, but that they seemed to be originating from a single point of impact on the back of his head. Is that correct?
It appeared so, yes.
Are you reasonably certain that all of his injuries were the result of a single impact to the back?
If she's in criminal law, she will have been doing trials. Like criminal lawyers, you do trials first year, and every year, always lots of trials.
Back of the head?
It could be a single impact.
But it also could be multiple impacts, correct?
It could be, yes.
Because as you just testified, Mr. O'Keefe suffered multiple injuries to the front of his face as well.
Correct.
In other words, he could have suffered a trauma to the face and then fallen and sustained the injury to the back of the head, correct?
That is possible, yes.
Now, this is a question: is how does he get the face trauma? Given the prosecution's theory, right? Because the prosecution's theory is hit on the arm and then launched backwards and lands on the back of his head. So where does the face enter into that? I'm like, tell me about that, right? How does this happen? It just raises more questions. And certainly the defense theory is he got punched. Right? That's where the defense is trying to go here, is he got punched.
And you testified before the state grand jury that the areas of bruising to the brain were likely due to a fall. Is that correct?
Yes.
In your expert medical opinion, Is it possible for someone to get punched in the face hard enough to lose consciousness and fall backward?
Objection.
I'll allow it.
It's possible.
If I can have one.
Sure.
May I see the exhibits that were just marked, Your Honor? Your Honor, if I could have permission to publish what's been previously admitted as Exhibit 19.
Yes.
Dr. Squirty-Bell, it's kind of hard to see in this picture, but there's some redness that you observe on the body by the ribs that we observed in some of the other photographs that were presented by Mr. Lally.
Do we have just a moment, Your Honor?
Yes.
Yes.
So I think that was Jackson saying basically I'm stepping in to give her a tip.
Previously marked as People's Exhibit 648. Ms. Gilman, would it be, Mr. Bates, could you take that down?
Yeah.
Ms. Gilman, would it be possible to display Exhibit 648? 648. May I approach, Your Honor?
Yes.
2853. Thank you. Dr. Squirty-Bell, you were shown this photograph by Mr. Lally on direct examination.
Yes.
Do you see the redness sort of next to his rib cage on the bottom? Correct.
Yes.
What is that?
That is livor.
Lividity?
Lividity. Yes.
Can you describe to the jury what lividity is?
Yes. Lividity is the pooling of blood to the dependent areas of the body after someone is deceased.
So even though it sort of appears to look like a bruise, that's lividity, correct?
That is lividity. Yes. It goes all the way down.
And it's not the result of an injury.
No.
Thank you.
Why are they doing that? Well, because otherwise on clothes you may see Lally say they said no injuries to the torso, but look at these red marks. She's specifically closing off that those red marks are an injury. It's just when you die, blood stops pumping, right? And when it stops pumping, just think of yourself as kind of like a sponge. You as a human being are kind of like a sponge because you're full of wet stuff and it's in little tubes through your body. And once you're not alive anymore and your heart's not beating and all of that, it kind of settles to the bottom. Especially the solids in your blood settle to the bottom and you end up with the blood resting down to the lowest point. Now, lividity can be critical in an investigation. Why can it be critical? Well, let's say you find somebody who is they've fallen off a cliff, right? That's the initial thought. And you find them at the bottom of the cliff. They've got all sorts of broken bones. And the initial thought is this person was out hiking. They fell off a cliff and they died. Okay. Now, let's say you bring out the expert. And the expert shows up and the expert looks around and goes, the lividity, is all at the top. They're face down, but the lividity's on their back. That suggests that they did not die like they were thought to, that they've actually been moved since that, settlement, which might take you from, hey, this was a horrible accident where somebody has, where somebody has fallen off a cliff while they were hiking, to maybe they were beaten to death somewhere else, and instead, and afterwards they were thrown off the cliff in order to cover the beating death, right? That's the kind of inference you might make from that. And you might, so the lividity might solve the issue there. So, yep.
No further questions.
Okay, the lights, please. Thank you. Mr. Lally?
Yes, Your Honor.
Yeah, guys, if you can, some people have asked, what can we do for Corey and his mom? Go over to Pixie the Crap Goth. Hit the subscribe button. Help her get to 100,000 subscribers. It's a help. So, yeah. It's one of the things you can do. All right, so that didn't go great for Lally, right? Did not go fantastic.
Dr. Squaybell, you did observe a minor abrasion to Mr. O'Keefe's right knee, is that correct?
Correct.
And what part of the knee was that on, if you recall?
It was on the side, on the lateral side of his right knee.
So a minor abrasion to the side of his knee. Okay.
Bilateral, sort of the side that faces away from the body, is that correct?
Correct.
You were asked whether or not the small injuries on Mr. O'Keefe's face could possibly be from a punch, is that correct?
Correct.
You said that's one of the possibilities, is that correct?
Yes.
What are some of the other possibilities?
Could be impact during a fall. It could be coming in contact with any blunt object in the snow.
Would glass be a possibility as far as a blunt object?
It could be under certain circumstances.
Did you hear that? It could be under certain Christ, he needed a yes, and what he got was maybe maybe oh man, maybe
Piece of plastic under certain circumstances as far as a blunt object, would that be all?
You know why he's asking the under certain circumstances is to keep her from saying under certain circumstances.
Also a possibility?
Correct. Yes.
Now, as far as the abrasion near the laceration on the back of Mr. O'Keefe's head, you were asked some questions about whether or not that could be from drag, correct?
Correct.
Now, as far as injuries or abrasions concerning dragging, would it be typical to see just one isolated abrasion in the area of a laceration?
Not typical, but possible.
You see the way she goes, not typical, but possible? I think she's got a theory. I think she's got her own theory. And I think her theory is the defense theory. Because she says not typical, but possible. She could have just said not typical. She could have just said no. That's my guess. That's my guess, is that her theory is that she, and I think she just can't say it. Like, she can't say that she's certain, certainly. So, yeah. Maybe. I don't know if there
Could that
would be
also be a
interest.
result of the blunt impacts, or as one of the possibilities you've testified before, from hitting the ground?
Yes.
Birth. I'm sorry, that was mean, but still, I had to.
Now, you were asked about hitting the ground and specifically hitting concrete. Would that impact injuries to the back of Mr. O'Keefe's head also be consistent with striking his head on frozen ground?
I'm sorry.
Objection.
No, I'll allow it.
Can you repeat the question?
You were asked a question on cross-examination about the laceration and abrasion to the back of Mr. O'Keefe's head being consistent with striking his head on concrete, correct?
Yes,
Would that also be consistent with striking his head on frozen ground?
could be. Yes.
You were asked about.
Now, here's the thing. This is terrible for the prosecution. This is terrible for the Commonwealth. You never see this. You never see the Commonwealth engaging in this line of questioning. You know why? This is the reasonable doubt line of questioning, right? This is what I do as defense counsel. Like, as defense counsel, you'll have a medical examiner saying, oh, I think that this injury was caused by, by a fist fight, right? And I'd be saying something like, well, isn't it the case that you can't actually rule out a fall, right? And they'd be like, well, maybe. It could be a fall, I guess. Maybe, possibly. And it'd be like, well, and, you couldn't rule out that they fell more than once, right? And they'd be like, well, yeah, I guess it would be consistent with multiple falls. Like, this is the defense counsel game. Why is Lally, like, when Lally is questing for doubt here, that is a problem.
Certain wounds as being a possibility of defensive wounds. What are some of the other types of defensive wounds that you would expect to see that you did not see in this case?
So he's asking, what kinds of defensive wounds could you see, but you don't see here? It's a very carefully phrased question, and good for Lally at the phrasing.
I would expect to see, or I have seen, multiple bruising to the, again, posterior aspects of the forearms.
Now, this is a place that I think they missed an opportunity on redirect. And here's why. She says bruising to the forearms is something you would expect to see as a defensive injury. You know what I would have asked on redirect or on recross? Doctor, you said you'd expect to see bruising on the forearms as a defensive injury. Yes. Does that mean that injuries to the forearms are often a defensive injury? Because they try to get in that the arm injuries could be a defensive injury. But yeah, I think you could sneak it in. I think you could sneak it in through that. And yeah. Yep.
I have seen cuts, lacerations, depending on how a person might be defending themselves, the position of their arms.
And would that also includes breaks in the fingernails and fractures to the hands?
Objection.
Watch the form, Mr. Lally.
The objection was leading, because that was leading as hell.
Sustained.
What, if anything, else would that include?
And you see, right after he leads, he then says, what, if anything, would that include? What is she going to answer, I wonder? What could she possibly say now?
It might include bruising to the knuckles. It might include
no idea, but
fingers.
I don't know.
Now, with reference to the injuries that you were asked about with respect to Mr. O'Keefe's right hand,
I don't even know who
those,
that is.
also be consistent with impact from a blunt object as well?
They are blunt impact injuries. Yes.
Now, I'm just going to note the broken nails is usually it's usually a defensive injury that I see in women, not men so much. Why? Because women seem to be more likely to have two things that lead to broken nails. Thing number one that leads to broken nails, long nails. Long nails break more easily, right? If you've got your nails cut tiny, you're a lot more likely to break them than you are if your nails are cut small. The other thing is women are much more likely in a defensive situation to do the clawing gesture, which can break nails, which can, guys don't tend to scratch as much. They just don't so much. Guys tend to punch more and get the injuries on their hands and so forth. So yeah.
Now, again, if I could, just with reference to, you were asked about different possibilities with the skull fractures and bleeding in the brain.
Yep, women are also dragged and choked during assaults. It's true. Women tend to, in conflicts, be the less physically strong person of the two, right? And the fights tend to go a little more differently. What is more effective in self-defense? A gun. So, yeah.
What is your opinion as to sort of how that was caused and sort of, if you could, again, just go through.
I'm just going to say, if you're collecting DNA evidence under your nails, that's a bad scene because they swab your nails if you die.
Your opinion as to the head injuries, the skull fracture, and the bleeding.
Objection.
Ask it again, Mr. Lally, in a different way.
You were asked about some possibilities. What is your opinion as to how those injuries were sustained or manifested in this room?
I don't know how they came to be. I described them and I stated previously that they are consistent with a fall to the back of the head.
And so I'm sorry, Doctor. My question is more geared towards as far as the single impact to the back of the skull and then sort of radiating fractures in the skull. If you could explain that in reference to the subdural hemorrhage, subarachnoid hemorrhage, and the ecchymoses that you observed.
Again, a single impact with a fall could cause all the injuries that we're seeing in the brain and the skull.
Single impact from a fall. We could actually get down to the level of just John O'Keefe leaves the party. John O'Keefe doesn't want to call Karen Reed because they've been having like drama. He doesn't want to call her. He figures, I'm just going to walk home, or I'm just going to go for a walk or whatever. And gets out somewhere and slips in the snow and I don't know, right? I just don't know. A dog attack causes fall near back gate, maybe. Yeah, maybe a fall after getting worked over. Maybe he gets into a fight, leaves the party in a hurry, pulls out his cell phone because he's going to call Karen, and he's like, oh shit, I'm in some injuries. And, I've got some injuries. It's a bad day. Pulls out his cell phone to call Karen, falls and dies. It's possible. And I got to do this. Cat Yarb says, I want the boom, but I also love your content. Here's to the pro bono fund. Thank you so much. Also, boom. So, all right. Yeah, I mean, I just don't know, right? Just falls. What about the cut to his arm? Maybe he got into a fight, left, and then fell and died. I don't know. Like, there's so many I don't knows to this. It just makes no sense whatsoever. Mm.
Okay, I know.
Hits his head and rolls over.
No further questions.
All right, doctor, you are all set. Thank you very much.
All right. So doctor is all set. She is done. I thought she was terrible for the Commonwealth, but the Commonwealth tries to get out some. Isn't it possible that our theory isn't completely excluded? You've mentioned you drive a Civic. How's that possible in icy Alberta? I drive it just fine in the snow. You put snow tires on it, it goes. You just learn to drive in the snow and ice. So, all right, let's go through some super chats. I have hiccups. I've been drinking this Moscow Mule, and I don't know why. The last month, carbonated drinks just give me hiccups, something fierce. Patty Hoffman, thank you for the 10 gifted memberships. Much appreciated. Azam Nuraza Jumberry, thank you so much for the super sticker. Much appreciated. It's even worse when I do carbonated beverages and talking on a stream. It tends to hiccup me. So Becky R, thank you for the YouTube membership. Cat Not Williams, thank you for the YouTube membership. Charlie Raven, headed towards 2 years. Wow, time flies. Wow. Thank you so much. Damon Stevens, thank you for the YouTube membership. Steve A, feels like it takes Grandma Badass as long to read off her qualifications as Trooper Paul spent getting his. Updated expert timer, 1090912. Nice. Yeah. Over an hour of her reading her qualifications, although she does do it twice. Scooby Williams, thank you for the YouTube membership. Brandy Rose, I'm sorry, what? I almost never catch you live. I'm going to catch most of this on replay because it's my bedtime for my kiddos. But I had to say hi, and I've been loving your recaps. Thank you so much, Brandy Rose. Cookie Mon Steve, isn't it mind-boggling how context is gone? It's a little mind-boggling. CW, you're a great dude, Runkle. Well, thank you. Ice Baby says, can we do something for Corey now to honor him today? I've got pinned his the fundraiser for his foundation. Also, you can subscribe to Pixie the Crap Goth. So, yep. Kim Carter, thank you so much for YouTube membership. Much appreciated. Azam Nuraza Jumberry, thank you so much for another super sticker. Much appreciated. Steve Kelsey, $5 used for snarking Lally. Thanks, Ian. Love your channel. Thank you so much. And Chelsea Rama notes Captain Corey. It's Kori. I don't think he'd have minded the spelling mistakes just so long as people... It's the sentiment. Joy W101, this Emmy wouldn't jeopardize her professional reputation for Proctor. I wouldn't cross the street for Proctor, but yeah. Carazola X, crazy that CW is trying to question defense witnesses' credibility after Trooper Paul. Defense should be allowed to put Coco the effing monkey on the stand, and Coco's dead. JC, thank you for the super sticker. Mary M, regarding Friday Night Frenzy, New York Times has said the Young Thug, YSL trial. Is it? No, it's not Young. It's YSL Melly, is it? As a test run for a Georgia DA's attempt to prosecute a certain former U.S. president and reality TV star. Really leaving that open under the same interpretation of RICO. Thoughts? Maybe, I don't know. It's possible. Random commentator, did you say possible or probable? She said possible. Melanie Hideki, she never said with all medical certainty, possible doesn't mean squat. Yep. Light Queen, she looks like she wants to say it's possible, but highly unlikely. Also not consistent with pedestrian collision. Yeah, she was skeptical of that. Dory G, after voicemails, I thought Karen has to be a criminal mastermind to have knowingly hit him. After Emmy, I have no idea what, if anything, hit him. Yeah. What, if any, side quest are we sort of on? Did you see the Commonwealth's motion for discovery? Yes. I'm not going to go over it today, but they're like, we have some new stuff we want to tender, possibly. It's not their motion for discovery. It's we have additional evidence that we want to call. So we are letting you know we have it. And yeah, we're declaring this evidence is I believe what that is. So Laura Lee Lanny, thank you so much. Rainman YYC, silly Runkle, metric units are freedom units. 9mm, 10mm, 5.56mm. You make a solid point. DSN, thank you for the gifted membership. Much appreciated. Moonshine 35, isn't it nice to have non-combative witnesses? Isn't it? Isn't it super pleasant to watch her YSL Young Thug trial in Fulton County, Georgia, Young Stoner Life? Gotcha. I'm getting confused on all that because I'm not following it. Isn't it nice to watch a cross-examination and a direct examination of a witness who just wants to answer questions, right? Who just wants to respond to what she's asked? Like, it's so nice to see that, right? It's so pleasant. I love that. I really liked the ME as a witness. Yeah, just is what it is. CGR 902, he hoped the jury would get tunnel vision. Yeah, he hopes that they're set on conviction at this point. Rainman YYC, thank you for the 10 gifted memberships. Much appreciated. Morena, we've had evidence of the ME being pressured for a different ruling from a bunch of good old boy cops. Plus, there's Lally's attitude. Little is the perfect choice for Cross. Yes, I do actually think her gender plays into it, like straight up. And if I was starting a law firm right now and I wanted like a second lawyer to work with, I might put a little focus on like, can I find a woman to, possibly offer a different style, different for different cases. It might make more sense for her to run some cases versus others. Dogs discussion. Thank you for the super sticker. Much appreciated. Amy T. I think the ME purposely let it open for the defense experts to come in by what she said. She doesn't seem happy with the theory. I kind of agree. Angie Torres, Houdini amorous. Yeah, Greg ME ended up being a strong start for the defense. Oddly enough, kind of. It really did feel like the defense started their case with the ME. It's almost surprising when you hear, like, I was almost like kind of stunned when you get like this moment or the moment where Lally says prosecution rests. I was like, oh, right. This wasn't a defense witness. This was the prosecution's witness. Okay. Just me. John O'Keefe head injury, expert panel on Aussie Insider, last Lally gaslight, including Andrea Burkhart. Okay. Justin Maxwell, Pixie, the crap goth. Corey's mom is trying to fulfill one of his final hopes by getting over 100,000 subs on her channel. Corey directly asked for this on a video. Yep. Try to make it happen, folks. Jack Druger, thank you for 10 gifted memberships. Much appreciated. Jordan L. Hey, Runkle, love the show and the deep analysis of these types of trials. Would you consider covering Barry McCulkiner versus Dixon's cider box affair? Maybe. I have only just heard of it now, so maybe. I can't say for certain. David Reese, the temperature at the time the prosecution claims the time of the accident or incident had just dropped to around freezing. The ground would not have been frozen. Fair, although I don't know how long it had been cold. Like, I don't know that. I don't know that we had evidence on that. Celine, Replay Crew Popcorn, and Whiskey Fund. Thank you so much. Noel Nidun, or Noel Ni... Yeah, I hope I've got that right. Okay, now that the Commonwealth is rested, can we get a poll? What did the Commonwealth prove? 1, Karen Reid guilty. 2, Karen Reid not guilty. 3, it snowed. I can already tell you that 3 is going to win that one. Mackenzie Jabelli, enjoying your coverage from Tennessee. Thank you so much. John Duncan, thank you for 5 gifted memberships. Debbie Kennedy, Lally needs to be rehomed. He needs to be re-ethixed. I don't know. I don't know what's going on with Lally. I mean, I think Lally thinks he's fighting the good fight. I think he's sure that Karen Reid is guilty and that he's trying to do his best there. So Billy's momzilla. So JM scratched and punctured JO's arm, not Chloe. I don't know. I doubt that. Miss Jewel SFL. Runkle, as a neopetty respiratory therapist, I've seen some things. This breaks my heart. This is not vehicular homicide. A head was beat. I've seen kids' beatings this way, as sad as it is. Don't block me for that, please. I'm not going to block you for that. No. Why would I block you? SF, most Commonwealth witnesses added to or were combative with their answers. If the defense witnesses just answer questions without extra nonsense, is this something jurors notice and factor into their deliberations? Absolutely. It makes you look tons more credible. Melanie Haydicky, why would Lally ask Dr. Russell if she knew about Chloe having a bite history when the jury didn't know that? I think that was a mistake, but we'll get to that right about now-ish. So, that's the medical examiner. Okay, I've been told that I fell for a streamer naughty with the court case super chat. Oh, I don't even know what that means. Okay. I don't know what that was about. So, okay. But all right, I'm going to do a swoop, and then we will talk about our next witness. Swoop. Okay, so here is the yeah, we don't need that. So here is sort of where we're at. First, I've been sort of told that I don't ask you guys to hit the like button enough. So please hit the oh, yes, I see what you're saying, Jordan L. I will not yeah, fair enough. I didn't even notice. I see what you're saying. I'm not going to read that one, Jordan L, for the same reason, but fair ball. Whoever it is, they got me. It is what it is. The Creakin, I really thought the ME played better for the defense than the Commonwealth, and I see why it took so long for her to take the stand now. I see what the... okay, so... what is it? Let's... so I've been told I got to remind you guys to like, share, subscribe, all of those things. If you want, if you want, you got the option to super chat. If you don't, that's fine. You're not required to super chat at all. So especially if money is tight, don't hit the super chat button. But let us move on to our next witness. And our next witness is, drum roll, please, Lucky. Lucky is kind of an interesting guy. We're going to talk about Lucky. I really like Lucky. So, but before we get to Lucky, we're going to talk about the motion to dismiss. We're going to watch that.
You are unmuted.
All right. So, Mr. Jackson, yesterday you told me you would like 10 minutes for your argument. Oh.
So, motion to dismiss. What does this mean? How many weapons do you have? It depends how you define weapons. But if you mean firearms, I have a little over 50. So, all right. So if you're wondering, like, what is going on here, the prosecution has just closed their case. So the defense now is making an argument that the case should be thrown out. Now I'm going to talk a little bit about that, and we're going to I think they made some tactical errors, but let's go from there.
Here you know.
Thank you, Your Honor.
In the room with me right now, Yeah, 5. Let me see. 1, 2, 3, 4, 5, 6, 7. At least 8 in the room with me right now. What's your favorite handgun? Depends on what the purpose is. I kind of like the CZ Shadow too, but yeah.
Your Honor, I'll be brief. The court must consider, after viewing the evidence in light most favorable to the Commonwealth, whether a rational jury.
So you might say, why is it most favorable to the Commonwealth? The reason why is because basically the jury is the one who gets to decide the questions of whether they believe evidence. So if it's just that a witness is not credible, then that goes to the Commonwealth, right? You got to assume that they will believe everything that is helpful to the Commonwealth and disbelieve everything that is unhelpful to the Commonwealth. So that is kind of what's going on there. So the jury gets to decide, the credibility. So this is just, if you give them their best case, can this go to a jury?
Find the elements of the charges beyond a reasonable doubt. And here, the case that the Commonwealth has submitted to the jury after resting is insufficient to meet such a finding. There's no question but that with this particular prosecution in this particular case, no reasonable or rational jury could come to a unanimous verdict in favor of the Commonwealth. I want to, if I can, focus my argument on count 1, 2, and 3 and a specific element of each count.
Okay.
In each one of those counts, there must be evidence.
Ever use one of your weapons in self-defense? I have had to defend myself, but not. I haven't had to use it. I've had a situation of display of a weapon, and I should note, it wasn't really a weapon. It was a tool that was sort of used as such for the purpose. So
That the vehicle killed John O'Keefe. There has been no competent evidence presented in the Commonwealth's case that Karen Reed's vehicle actually struck John O'Keefe. There's been conjecture, there's been speculation, but no actual competent evidence. The Commonwealth's entire case relies on a theory built on the shoulders of a trooper named Joe Paul, who testified a couple of days ago.
The second one.
And his theory, according to the Commonwealth, is that John O'Keefe's arm was struck, he was spun around in sort of a pirouette, he was projected 30 feet to the left, hit his head on a curb or the road in the intervening time before coming to a final rest spot about 30 feet away. Everything.
Now, I'm just going to say, his notion about the about this, I think that this is defeated by the DNA evidence, because the DNA evidence, you can conclude that it might be that it might be caused by some other thing, but viewed most favorably to the Commonwealth, the DNA evidence could be towards could lend towards a conviction, right? So, yeah.
In the Commonwealth's case, everything relies on that theory of damage to the taillight at the scene. If a rational jury could not unanimously determine that
I don't really like the
Joe
burn-up.
Paul's theory is true beyond a reasonable doubt, then we believe the motion has to be granted. There is no competent medical evidence to support that theory. There's no competent physical evidence.
Now, let's just talk about these motions to dismiss. How often do motions to dismiss succeed? Almost never. Almost never. And usually when they do, it's because the prosecution has made a terrible fuck up. So let's talk about what that screw up could look like. A friend of mine won one at one point. And he won one because they just never called any evidence as to when the offense happened. And that was part of the offense. Typically, it's because the prosecution has forgotten to ask a basic question like, hey, did this crime actually happen here? Right? Really, really uncommon. I've talked to prosecutors. I've talked to prosecutors with like a 40-year history. And, you know, you can ask a prosecutor who's been practicing for 40 years and you ask them, how many times have you lost one of these? And I guarantee you it's less times than they have fingers. And that's including if they're into doing woodwork while drunk. So, yeah, they're tough. Is the jury listening to this part or no? The jury's out of the room. The jury's not hearing this. So, yeah.
That the taillight could break and shatter in the way that they've suggested, and that the arm would not have any breaks or shatters or any damage, any additional damage. There's no evidence how getting hit in the arm could actually launch a body 30 feet.
If the motion to dismiss is granted here, because jeopardy has attached, the prosecution could not bring the case again. That would be the end of it. So, yeah.
As per the Commonwealth's theory, and there's no evidence how a body hit by a 7,000-pound SUV could sustain no injuries from the neck down, which we just heard this morning.
That's pretty much it. It's just once.
Before the court, the only evidence that is before the court is that the Commonwealth's own medical examiner does not.
I can tell you, most prosecutors will have a sheet somewhere where they've got the elements that they have to prove, and just as a checkbox, and they'll just check them off as they go. So, yeah.
Believe this is a homicide. And she went on this morning to say that in her expert opinion, the injuries are not classic pedestrian injuries. And they are, every single one of them, consistent with a physical altercation. Calling a witness to simply espouse an opinion like Trooper Paul did that belies...
I think this is a perfectly reasonable opinion for people to have, is you can think she did it, but that the Commonwealth hasn't proved it. And that's the thing, is reasonable doubt, like the standard of beyond a reasonable doubt, that's what that's all about. You can get to the point of, where you're like, hey, I am like 75% sure she did it. And if you are at 75% sure she did it, you've got to acquit. That's the rules. That's the rules. Is this done in front of the jury? Anybody? It's not done in front of the jury. Jury's out of the room. So, yeah. And I got to roll. Runkle, I've seen that. It's not a car, it's a beating. As a neopedi respiratory therapist, I've seen that in my 30 years. I'm disgusted. This has come to trial. I don't disagree with you. It looks way more like a beatdown than it does like a, than it does like that. So, yeah.
Science, common sensory, and logic, that's not enough to get the case to the jury. The light most favorable to the Commonwealth does not mean that the court must believe the Commonwealth's witnesses.
No.
What it means is that if there is a rational controversy in the evidence, the court must accept that evidence that favors the Commonwealth. But here, there is no rational controversy. As put or expressed in Commonwealth versus McCormick, it's a 2023 case found at 491 Mass 848, pinpoint site 860, quote, where the Commonwealth's evidence is entirely circumstantial, it cannot meet its burden if the evidence equally supports inconsistent propositions, as resolution of such a case necessarily requires conjecture or surmise. In our view, there is no question that there's no rational controversy related to the Commonwealth's theory. Trooper Paul's theory is by definition not rational. It's not reasonable. And it's basically based entirely on conjecture. And that's why, in our view, the court is required to find Ms. Reed not guilty of counts 1, 2, and 3. It's because each of the counts, as I said at the beginning, necessarily include an element that John O'Keefe was struck by Karen Reed's vehicle. Thus, if a rational jury cannot reasonably believe true for Paul's theory, it's the only evidence presented by the Commonwealth describing how Mr. O'Keefe possibly could have been struck, then Ms. Reed is entitled to an acquittal. Nothing else matters. Nothing else in the court's evaluation, nothing else in the jury's evaluation, nothing. Everything turns on whether or not the car hit John O'Keefe. And the Commonwealth's only theory of how that happened is from Trooper Paul's description. If the court were to deny this motion, then by doing so tacitly, the court is expressly endorsing Trooper Paul's theory of how John O'Keefe was struck, and we don't believe that that's rational. We don't believe that any rational jury would ever unanimously agree with Trooper Paul, and thus we ask the court to find Ms. Reed not guilty at this time.
Okay.
I'll submit.
I'm just going to note, as soon as he was done talking, I was like, he's not winning this. There was no chance he was going to win this. Just full stop, right? Just wasn't going to happen.
Your Honor, if I may just, we have a written motion for the
Okay.
court to act on pursuant to that argument. May I hand it to your clerk? Copy for the court.
All right. I will hear you, Mr. Lally.
Yeah, you forgot the thing. We have written submissions.
Yes, Your Honor. Surprisingly, I would disagree with counsel's.
It was a decent presentation. Yes, they did the best they could with what they had. Now, what I would say is that if I was them, I would have probably made arguments to specifically attack like murder and take murder away from the jury. To say like, listen, you should remove the intent element because they haven't had any evidence as to intent. I would have tried that. People are saying, please don't make us listen to Lally. We got to listen to Lally, guys. We'll take it up to 1.25.
So let's leave the comments out.
Your Honor, as far as the comments,
So the comment she was talking about was he starts off and says, well, this.
yes, Your Honor. Surprisingly, I would disagree with counsel's
So let's leave the comments out.
Obviously, you disagree. You're the prosecutor. If you thought that there was not enough evidence to send to the jury, you would just stand up and say, or you would have just ended this material already. Like you would have just said, prosecution rests and invites a dismissal. Yeah.
Your Honor, as far as the comments, all I was going to say is that I would submit to the court that,
Is this surprisingly that I took issue?
and my apologies, what I would submit to the court.
The judge is so tired of them sniping at each other. And she's like, can you drop the freaking sarcasm? It's unnecessary. Just argue your motion, right? Just argue your motion. So what's better for a client? Long-term successful motion to dismiss or an acquittal? Either is legally the same thing. It's really just depends on optics of the scenario. Most clients don't actually need to worry about optics because most trials don't get any interest. So,
Your Honor, is that this case does not rest and fall with the testimony of Trooper Paul. Trooper Paul's testimony, while important, when taken in conjunction with the remainder of all of the other witnesses and all of the other testimony that the court has heard, I don't want to minimize it, but at the same time, that is not the only evidence that the vehicle struck Mr. O'Keefe or interacted with Mr. O'Keefe. So what the court has,
yeah, that's quite possible.
As far as the physical evidence next to Mr. O'Keefe's body, one sneaker.
There was no chance that the defense was going to win this, right? So you just make the argument, and then you move on, right? That's it. You make the argument because you have to, because you wouldn't want to be in a situation where the judge was inclined to grant the motion to dismiss. You didn't ask for it. That would be crazy, right? So you always make the argument, but yeah.
in the location of the curb. The glass, the drinking glass that Mr. O'Keefe is seen walking out of the Waterfall Bar at approximately 12:11 a.m. with that is in the vicinity, the direct vicinity where the Canton police officers actually recover it early in the morning of January 29th. You have the microscopic pieces of the defendant's taillights, which was testified by Ms. Hanley to be consistent with pieces of the taillight from the defendant's vehicle that are within or embedded within Mr. O'Keefe's clothing. You have the remainder of the pieces of taillights, and this part is important in relation to Paul's testimony as far as the linear momentum, and it's all in the same sort of direction and path of all of the roadway evidence that he observed as discovered in and around the area where Mr. O'Keefe's body was. The testimony from Ms. Valier, with reference to all of those taillight pieces and how they were able to reconstruct from the pieces that were found on.
Okay, so he says Ms. Valier and then he corrects it to Mix Valier. Okay, I guess that answers that question because it was complicated back then.
The ground and then put back together, matching with that, but the taillight housing from the defendant's vehicle. The taillight housing from the defendant's vehicle, which has the victim's, Mr. O'Keefe's DNA contained on it, as well as the mitochondrial DNA testing of the hair that was on the rear right quarter panel of the defendant's vehicle, which also was matched or consistent with that of Mr. O'Keefe, his mitochondrial DNA, as well as what heard from his chart from voting technology. You have the plethora of testimony from the various civilian witnesses from that particular night. You have the evidence of motive from the text communications, as well as the testimony of the children in this case as to the state of their relationship from the defendant's own mouth in those text communications and in those voicemails as to the state of their relationship. You have the testimony in regard to Mr. O'Keefe and his recounting of the state of their relationship and his numerous attempts to break it off with Ms. Reed prior to that date. There are arguments that continued throughout the afternoon of the 28th. And seemingly into the 29th. You have the defendant's own statements that I hit him, that come from multiple sources, including firefighter Nuttall, firefighter Famati, firefighter McLaughlin, and Ms. McCabe. You have her statements to the paramedics in the back of the ambulance that the last time that she saw Mr. O'Keefe, they had gotten into an argument. You have the testimony in regard to Ms. Roberts and Ms. McCabe as far as the altercation or the verbal argument stemming from Ms. McCabe's reference of Bella's mother. Being a landmark, being someone that Mr. O'Keefe used to date just prior to that argument occurring in front of the house at 34 Fairview Road.
So he's got to go through his evidence to say, hey, there's enough
of evidence that was presented throughout the course of the Commonwealth's case, including the forensic evidence, including especially one thing I would stress for the court is taking not only Trooper Paul's testimony, but Trooper Paul's testimony in juxtaposition to Trooper Garino's testimony as far as the vehicle or the native GPS locations of Mr. O'Keefe's phone in reference to the timing and in particular the information or data from the Toyota text string. Trooper Garino's GPS native location of Mr. O'Keefe's phone has that reversal, the same 3-point turn that Trooper Paul testified about, which occurs 8 minutes prior to the vehicle traveling 24.2 miles per hour for approximately 62 feet in a straight line in reverse. And as far as the testimony and the evidence that the court has before it, the court also has those backup testing videos that Trooper Paul conducted with the defendant's vehicle, so the court can see exactly what that vehicle looks like at approximately 25 miles per hour in reverse in a straight line. And what I would submit, Your Honor, is that there's more than sufficient evidence from a medical perspective, from a forensic perspective, from a civilian witness perspective, and from the investigation of this case as to all three indictments that the Commonwealth has met its burden, particularly under the standard before the court at this time. And for those reasons, I would request that the defendant's motion be denied.
Okay. Right. In the light most favorable to the Commonwealth under the prevailing Lattimore standard here in Massachusetts, I am satisfied the Commonwealth has met its burden. The defendant's motion is denied. So, Mr. Yannetti, are you calling your first witness?
Okay, so that is what has happened there. Yeah, that is kind of where we sit. That was expected, right? So it is what it is. All right, give me 1 second. We're going to roll on.
Yes, Your Honor.
Okay, so let's bring the jurors in, please.
Oh, and I've got to cover something here before we move on too far. Let me just pull that up. Bruce, I cannot see how a taillight that is almost fully intact at 5 o'clock in the morning as the car leaves John O'Keefe's house and seen on Ring video could possibly wind up on the lawn of Brian Albert's house 3 hours or 4 hours before. It is definitely an open question, and I owe you this. All right, let us roll on here. So we need to get Lucky up on the stand.
Voice, would you state your name and spell your last name?
Sure, it's Brian Loughran. It's Loughran.
And where are you from,
Mr.
sir?
Loughran, I'm going to ask you to keep your voice up as loud as you can, sir.
Sorry.
That's okay.
Maybe put your mouth as close to the mic as you can. Where did you grow up, sir?
Canton, Mass.
Is that where you live?
Yes.
How long have you lived there?
Both 35, 36 years.
And did you go to Canton Public Schools?
Yes.
Now, in the course of living in Canton, were you familiar with the Albert family?
Yes.
Which members of the Albert family were you familiar with?
All of them.
And when you say all
I like the just all of them. So, yeah.
of them, can you name the ones that you were familiar with?
I was familiar with Brian,
Brian Albert?
Chris Albert, Brendan Albert, Kevin Albert, and I believe Kathy Albert is the sister, but I'm not 100% sure on her first name.
Okay, and those are the siblings that you had contact with and were familiar with?
Yes.
Did you know some better than others?
Yes.
Whom did you know the best?
Chris Albert.
What is the age difference between you and Chris Albert?
I believe we're the same age.
Did you graduate high school with him?
He went to a different high school, but
Okay.
yes,
Graduated at the same time.
correct.
And with regard to your familiarity with Chris Albert, can you explain to the jury how you became familiar with him and what your relationship with him has been?
I went to school with him, elementary school. We went to middle school. Then he transferred to a Catholic school. Then later in years, I began to work for Chris for D&E Pizza, delivering pizzas.
Okay. And approximately what ages were you when you were delivering pizzas?
Okay, so let's talk a little bit about Lucky, because this is Lucky. Lucky starts off delivering pizzas. He's the only person who's actually admitted, like, he's the only person who's like, seems like he's just is okay about knowing the Alberts. He's like, I started off delivering pizzas. That's what that's what I did. I then went on to sewer work. I'm going to tell you, sewer workers, it's not a fun job. It is it's often a really shitty job in the most literal sense of the word, right? But he was willing to do it. Now he works the plow. This guy is like the salt of the earth guy, right? And yeah, he's about as sort of just doing his job kind of thing, right?
In to do plowing
All right, so let's talk about, let's move on a little bit.
that evening or early morning.
I love the tagline that Court TV puts on about friendly with the Albert family. I can guarantee you that after his testimony today, he is not friendly with the Albert family. Albert family is not going to be liking this guy.
We're told to be in by 2:30
And is that 2:30 a.m. or p.m.?
a.m.
Would that now be?
Well, I get that. He said he worked sewer, and then he noted that water and sewer are sort of together. So, yeah.
On January 29th.
Correct.
What time did you arrive at the DPW that early morning?
About 2:15.
When you got there, what did you need to do in order to go out plowing?
I needed to get into my truck and get that prepared to go out.
All right. And your truck, is there one that's specifically assigned to you when you plow?
Yes.
And does that truck have any particular nickname?
Yes, it's called the Franken truck.
And why is it called the Franken truck?
It is a truck that has a lot of different parts than what it's required. It's not parts that were made for that specific truck.
Oh, this guy is so precious. He drives the Franken truck, which, you know, he's like, it has a whole bunch of added parts. I don't know. I kind of get the sense this guy might be a bit neurotypical, or neuroatypical rather, bit neurospicy. And yeah, this guy is so, you just kind of want to give this guy a hug. And yeah, he's so, all right, let's jump on a little bit. We'll jump a little bit ahead.
But I can see a real long distance, the visibility.
This guy is a sweetheart. This guy's a sweetheart.
Is fine. It is extremely, if you gave me probably 5, 10 feet, 15 feet out, maybe even further.
Okay. And with regard to the lighting, how much light does that give off?
Enormous amounts. It's almost driving with the spotlight.
And with regard to the air ride seats, what action did you take with those that particular night?
I raised it so that the bottom of my knees would hit the steering wheel.
And what, if any, obstructions, I should say, were in front of you that would prevent you from seeing what's in front of you or to the side?
Nothing.
All right. Now, do you have a specific route assigned to you?
Yes, I do.
Could you describe that route? And by the way, that specific route, was that the one that you were assigned on January 29th?
Correct.
Could you describe that for the jury?
Yes, it's a route that consists of Cedar Crest from Kings Road to Chapman Street and everything in between. There are a lot of streets I could name if you would like, but
he's like, I can name every street.
Fairview is one, Spring Lane is one, Cedar Crest, Kings Road. Those are pretty important roads that I would consider major roads on my route.
All right. Now, that particular night, if you got there at 2:15, what time do you think you were on the road in Franken truck?
I was on Cedar Crest about 2:30, 2:35.
Now, with regard to Cedar Crest, I would like to show you a map if I can. May I approach, Your Honor?
Yes.
I've handed you a document. If you could just review that to yourself and then look up at me when you're done. Do you recognize what's depicted on that?
Yes,
What is it?
it is my plow route and consisting of streets that I plow.
All right. And to be fair, that's a portion of your plow route, right?
Correct.
There are other areas of the city that you plow?
This actually depicts my actual physical route.
Oh, okay, great. And that's a fair and accurate representation of the streets as they existed back in January of 2022?
Yes.
I would offer that, Your Honor.
Any objection, Mr. Lally?
No, Your Honor.
Okay.
I did not get a timestamp for one thing that I meant to get a timestamp for. Why did I forget to get a timestamp for this? He's being asked like, hey, why is it important to be careful? And he's like, because you don't want to run over a person or, God forbid, an animal. He's such a sweetheart. and he's just so, he doesn't seem like he's got a dishonest body or bone in his body. So yeah, let's move on to an interesting part here. Something I took note of.
Where you wound up back at Cedar Crest and Fairview.
About 45 minutes.
So I think you had previously testified you made the first pass around 2:45.
Correct.
So would that put us at about 3:30 when you're about to make the second pass?
Objection.
Sustained, ask it different.
Sure, I'm sorry. What time was it, to your best estimate, in terms of when you would have approached Fairview and Cedar Crest again?
3:15 to 3:30.
Now, when you approach that intersection, again, are you approaching it such that Fairview would be on your left or your right this time?
On my left.
Same as last time.
Correct.
What do you do when you approach Cedar Crest? I'm sorry, when you approach Fairview and it's on your left?
At that point, I have an option. I can go to the end of Cedar Crest, or I can turn around at a street, depending on how much snow I have on Fairview.
And with regard to the decision you made regarding that choice, what decision did you make on January 29th at 3:50?
Went all the way to the end.
Went all the way to the end of Cedar Crest?
Correct.
Same thing you did the first time?
Correct.
And then you come back up?
Correct.
Is Fairview on your right or your left at that time?
It would be on my right.
And did you take that right?
Yes, I did.
What, if anything, unusual did you see at that point?
At that point, I saw a Ford Edge on the side of the road
Where was it parked on the side of the road?
in front of the Albert's house,
Where in front of the Albert's house?
by the flagpole.
And why was that unusual?
The Alberts never had cars that were parked out front, and it just stuck out as weird.
Now,
Hit the like button, folks.
Like that point. This is now, I think you said about 3:15 to 3:30.
Hit the like button if you can.
It's starting to accumulate a lot quicker than what it was previous.
And what policies does the DPW have regarding cars parked in the street during a blizzard where there's plowing to be done?
We are to notify the supervisor. At that point, he will make a phone call to the police, and depending on if they can have the resident move it, it gets moved. If not, it gets towed.
And
Okay, so this, you can tell Canton is not a huge town because in my town, if you're parked on the street during a plowing day, your vehicle just gets towed, right? You just, that's what happens. But here they say basically if you park on the street during a plowing day, and the plow can't do their thing, like the reason why this is a big issue is because if you're trying to plow and there's a truck there, you can't really plow that spot. So normally he calls it in, and they either call the person and say, "Can you move it?" or they just send out a tow truck and they move it and off it goes. Now he doesn't do that. Why doesn't he do that?
with regard to that policy, did you comply with that policy in those early morning hours?
No, I did not,
Why?
because I was being courteous to the Albert family.
He does the Albert family a favor. He does the Albert family a favor. And that, I think, is, it tells us a little bit about the Albert family and that they've got some pull in that town. But it also tells us that this guy probably isn't a dude who hates the Albert family, right? Because if he hates the Albert family, what does he do? He just calls it in, right? Screw you. You're getting towed, right? Now, if he had called it in, that would have been great for the defense, because then the defense, let's imagine he calls it in and they tow it. Then it would be very difficult for the prosecution to argue that Ford Edge wasn't there, right? Because there'd be records of it in the police lockup. All right, let's move on a little bit. We're going to get through this tonight, folks, I swear.
You are unmuted.
Just a couple questions, Mr. Loughlin.
Sure.
I hate the AI summary.
At any point
legitimately.
in 2022, were you ever approached by any police investigators, sir?
No.
When was the first time that you were approached by the state police in this case? Do you recall?
I don't recall the actual date, but I do know.
Year?
Yes.
What year was that?
2023.
And do you recall the name of the investigator that approached you?
Mike Proctor and Sergeant, and I can't pronounce his name. I don't want to.
Don't. He's like, I can't pronounce his name. I don't want to mangle it. Don't Jen McCabe it, sir. Don't Jen McCabe it. Yeah.
If I said Buchanan, would that ring a bell?
Yes, it is.
So why is Lucky's testimony important? Well, because he drives this plow at a time when, according to Lally's theory, John O'Keefe should be in the snow dying. And Lucky drives his plow. So Lally needs for one of two things to happen. He needs for either Lucky to have driven his plow by at a completely different time, or he needs for Lucky to somehow have missed John O'Keefe's body. And so we'll get to sort of how he approaches that. He's gonna try to attack some things here. So
A Ford Edge at nighttime in a snowstorm.
Oh, Julie Albert,
between
right.
A Ford Edge and a Jeep Cherokee.
don't Julie Albert it.
What's the
Gotcha.
difference?
The taillights in the back.
Okay, so we got to go back a little further.
Showing you different vehicles and asking you if those vehicles matched what
We got to go even further back.
them or hit them or anything like that, correct?
Correct.
Yeah, let's leave his wife out of it. Lucky is just here as, he's a witness, right? And whatever you think of Lucky, don't bring his family into things. So don't do that.
And on February 15th, 2022, when you had this meeting with Paul, you told him about 3:30 or 4 a.m. Is when you saw this Ford Edge on Cedar Crest, correct?
Correct.
Now, in fact, when you first spoke to this individual named Paul, you didn't tell him it was a Ford Edge, correct?
Nope. Told him it was Ford Edge.
You didn't tell him.
Yes, you absolutely can, because it's still the prosecution's job to prove it. So, yep. So the issue here is Ford Edge versus Lexus SUV.
First that it was a small SUV.
Nope. Told him it was Ford Edge.
You remember at any time Paul taking you on the parking lot and showing you different vehicles and asking you if those vehicles matched what vehicle you saw?
No. He wanted to make sure that what I was telling him was accurate. So he showed me what was a Ford Edge, but I had already told him it was a Ford Edge.
So he brought you out to the parking lot at the skating rink that you were meeting at, specifically showed you a Ford Edge and asked you if that was the vehicle.
Correct.
Now,
But he'd already said it was a Ford Edge, right? And now Lally's going to try to trip him up, and I'm going to explain the trick here. I'm going to explain the trip up and why Lucky is the scariest MF witness you can encounter. So,
do you know sort of the difference between, if you were to see a Ford Edge at nighttime in a snowstorm, the difference between a Ford Edge and a Jeep Cherokee?
Yes.
What's the difference?
The taillights in the back.
What about them?
Ford Edges are more round. The whole back facade is a little bit more round. A Jeep Cherokee are more square.
now, Lally did not expect him to be able to answer this at all. And I will tell you, most witnesses would have a very, very difficult time with this, right? Like if I ask you the difference between two cars that are nothing alike, how could you tell in the dark the difference between a Honda Civic and I don't know, guys, help me out with a car. Like, a Honda Fit, right? So, how could you tell the difference in the dark? Most people would actually have a hard time, like, yeah, Toyota Camry. Most people would have a hard time identifying the specific, distinct features that make them different, right? You know a Honda Civic when you see it. You know, a Kia Soul when you see it. You know all of these things when you see it. But actually coming up with the details without sounding like a complete idiot on the stand is really hard. What does Lucky do? He's just like, here's the difference. They have different rear lights. That is it's a gotcha question. Like lots of people would just have to say something like, I just know them when I see them, like I could tell them apart. This guy, now, if you ask me right now, I can't even describe my own car's taillights. If you ask me whether my car, and I have known that I've noted that I drive a Civic. If you ask me if my car has more round or more square taillights, I don't know. Like, I don't know. This guy, like, him having an answer is like one in, when is that going to happen? Amanda is saying, I could tell you from a mile away just from the lights and which year's models. Some people are really good at that. Some people are not. But I don't know, right? I don't know offhand what a Civic has or doesn't. So, yep.
Now, what color was this SUV that you saw?
I can't tell you that. I am colorblind.
Can you tell?
So colorblind, he's like, ooh.
And I'm just curious, sir, as far as your color blindness, can you tell whether or not an object is dark or light just by looking at it? Or you
I can see things that are light. I can see things that are dark. I can see true colors. I can't see shades of true colors.
And so from what you...
That's a really good answer. So he can see red or blue or green, but he might have a real hard time with like purple, or a real hard time with like, is it light blue or whatever else, right? I'm just like, and you see the way he answers, where he's being very, very careful with his answers to be clear about what he's saying. He wants to be precise. He wants to be exact. I love this guy as a witness. I just think this guy is amazing. He is my favorite person so far. Favorite witness of this trial right now. Lally. Or sorry, Lucky, not Lally. Yeah, this is the other thing. That's why he struggled with the blue on blue map Yannetti had. Yep, Yannetti showed him a terrible map for a colorblind person. So, yeah.
Show counsel.
So I'm going to ask you to read, showing you a document. I'm going to ask you to read this paragraph, and this paragraph.
So a friend of my dad's is really colorblind, like super colorblind. And it's funny because my dad has a story of when they were out there, they were looking at a sailboat, and he's like, look at the sailboat with the brown, with the brown sails. And everyone was looking around going, which one? And finally he sort of points and he identifies it. And they're like, that sailboat's sails are bright purple, not brown. It was like, oh, okay.
Yourself, okay? And then whenever you're done, just report that, right?
The other thing is that same friend, his colorblindness was so bad that occasionally he'd show up for something and he'd wear, and this was like rare, but occasionally he'd show up for something and the shirt he'd be wearing would be something like, vivid pink. And the way that would happen is that he would go to stores to buy a shirt. And so he picks out a style he likes, and then he'd flag down a service person. And he'd say, what color is this? And usually they'd help him out. They'd say, oh, it's a blue, and whatever else and so forth. And yeah, that was fine. But every once in a while, somebody would think that he was kind of fucking with them. So he'd pull down like a bright pink shirt and he'd ask them, what color is this? And they'd go, yeah, it's blue, man. And so he'd buy this shirt thinking it was blue. And if you actually looked in his closet, the inside, he would sew a tag on all of the inside of his shirts for what color it was, so that he could pick out a blue shirt and blue pants and like have matching stuff. But somebody would be a dick to him, and so he would show up to something in a bright pink shirt, and you'd be like, what color do you think that is? And he'd be like, blue? It's like, no, man. And you'd be like, that fuck. Somebody got to him. He was just like, okay. So, I mean, it just is what it is. All right, so let's keep going here. Oh, wow. This is ironic because the guy actually used to work for, I think it was a telephone company, but it was an electrical company. And he got fired when they realized how colorblind he was. But he used to do a great job because he kept his wires memorized, like he kept his wires organized by color. And then he would, then he'd just make sure to follow everything. He wouldn't rely on the colors. So he did a great job. But they eventually fired him for colorblindness. And then he went on to work somewhere else. But yeah. I think it was the 70s. Not if they can connect it to. I don't think he wanted to sue them, but they might be able to say like he can't reasonably do the job. That said, he was doing the job just fine for over many years. So,
Are you finished, sir?
Yes.
I would have sued, but
Yes.
Mr. Loughran, after having reviewed that, as your memory refreshed as to that conversation you had in May of 2023,
No, it does not.
do you still, after reading that, don't recall telling anybody in May of 2023 that you came in around 11:30 p.m., 12 a.m. on the 28th, 29th?
I never came in at 11:30, 12:30 at night. It was 2:30 calling.
So I love this because they're like, hey, we, he's like, I'm showing you a record of you talking to some officers to say that you had this time. And he's like, does that refresh your memory? He's like, no. And he's like, what do you mean no? He's like, that conversation didn't happen. And here's the thing. I believe him, because if the call-in actually happened at 12:30 at night, I can guarantee that Lally would have had records of when the call-in was, right? I can guarantee that he would have pulled that. And you know what else? As much as Lucky is a sweetheart, you know what I can guarantee he's not freaking doing? I can guarantee that he is not going to work early to plow snow. Like, he's not going to work until he gets called into work, right? Like, obviously not. So, yeah, and yeah, this would be the police report with Proctor and Buchanan talking to this guy. So I believe Lucky here. The notion that Lucky went to plow early before the call-in just makes no sense to me. Just like, sorry, why would you do extra work? You don't
recall indicating to anyone in May of 2023 that you went past Fairview at 12 a.m. and 2 a.m.?
Correct. Never did.
And you don't recall telling anyone that you saw the car around 1:30 or 2 a.m.? Is that correct?
Correct.
And you don't recall telling anybody that the part of Fairview containing 34 Fairview was blocked off at 3 or 3:30 a.m., correct?
Correct.
Now,
so Lally was really hoping that he would say, yes, I did say that, but here's why that wasn't true, and here's why I made the mistake. And then he gets to impeach. And instead, it's just like, I got nothing, right? All we've got is that he testifies to one thing and that Proctor and Buchanan testified to another. And I can guarantee you this guy is more credible than Proctor is. So, yeah. I think that this actually makes Proctor look worse than it does to Lucky. So,
if the part of Fairview that you were talking
in wrestling terms, that was a complete no sale, right? That was a complete no sale. Just, yeah.
About. So you didn't say that in May of 2023 because at 3 or 3:30, the roadway wasn't blocked off, correct?
Correct.
It was blocked off sometime around 6 a.m., correct?
Correct.
And so if you had said that the roadway was blocked off at 3 or 3:30 in the morning, and it was actually 6, then when you saw the vehicle would have been off a little bit as well, correct?
Objection.
Sustained.
The objection was basically that Lally was testifying, not asking questions.
Seeing the car at 1:32 in the morning, with the road being blocked off at 3 or 3:30 in the morning. If the road's blocked off at 6 a.m., then that actually would have been, you saw a car sometime around 5 a.m., correct?
Objection.
Sustained.
Sure you didn't see a black Lexus SUV in front of the house at 34 Fairview Road around 5 a.m.?
No.
That was a dumb way of asking the question. Are you sure you didn't see the black Lexus SUV? He says no. Does that mean no, you're not sure, or no, you didn't see it?
Now, you also were asked some questions and you spoke to some troopers in August of 2023, correct?
Correct.
And County Canton, they have a parking ban in Canton, is that correct?
Correct.
That goes from November until April?
Correct.
Parking ban is so they can plow stuff, right?
Now, part of your plow route is a road called Tippy Cart, correct?
Correct.
Where is Tippy?
Wait, did they just say a road called Tippy Car? What a silly name, Tippy Car.
Card in relation to Fairview.
It is on top of it's on the right side of Cedar Crest. It would put it 2 streets before Fairview.
And at some point, when you were plowing on Tippy Cart that night, you actually hit a basketball hoop. Is that right?
Yes.
And did you call?
So Lally here is trying to attack his ability to see things. And once again, Lucky Lawhorn is going to just no Salem on it. Watch this. This is wonderful.
That in?
Yes.
And as a result of that, what happened with the basketball hoop after that?
Nothing. The point was to make sure I was covered, basically. That's why I notified my supervisor that I hit the basketball hoop.
About
Basically, you hit a thing, you report it, right? Because otherwise he could be potentially on the hook for it, I guess. So that probably just puts it on the government's insurance rather than his, right? So, hey, I hit a thing. Whoops, our bad. I see that they've updated it to snowplow driver. Yeah.
what time was that you hit the basketball hoop?
I don't recall.
Is it closer to when you started, closer to when you ended?
I don't recall. I don't recall what time.
So you don't recall anything specific about that time, correct?
No, just that I know I hit the basketball net.
And obviously, and I'm not trying to put words in your mouth or anything, sir, but you didn't intentionally hit the basketball hoop, correct?
Correct.
So you
You didn't intentionally run over the basketball hoop. I mean, obviously he didn't, right? So, yeah.
hit it because you didn't see it, correct?
No, I was attempting to avoid the net by going around it, and the machine had a different size body than what it originally had, and I underestimated when I was going around that I need to be wider.
Holy crap! This is like the Matrix moment where, you know, the where they unload on him, and he just like dodges and weaves because it's like you hit it because you didn't see it, and he's like, that is not true. I hit it, or I saw it. I just misjudged my truck because it's the Franken truck that they keep modifying, and it was bigger than I'm used to. It is absolutely the Matrix dodge of that, because that was one hell of a good question from Lally. Lally's question was excellent. That was a sniper rifle shot to really put a hole in Lucky's testimony. And Lucky just was like, nah, bro. Stopping that shit right there. Lucky is my favorite. Like, Lucky is amazing on this. And yeah, all that Lally needed to do to blow up this guy's timeline was produce his time clock punches, and he didn't. The reason why is because I'm guessing his time clock punches are consistent with his testimony here today. He just wanted to get him on having made an inconsistent statement. And yeah. Lucky is so good. Like that is exactly what you want out of a witness. And this is the kind of witness that just ruins your absolute day on the other side. I think Lucky is amazing. He's just to Lucky. Like, yeah, I think Lucky is fantastic. So I'm a huge fan. All right. Let us do a swoop. Let me just see. What's a good swoop here? Swoop. Okay, let's go and cover some super chats before we move on to our next witness, who is going to be Grandma Badass, the grandma with every degree that has ever existed, and some that are probably yet to be invented. Kathy Wright, why does the prosecution get 2 shots at a closing argument and hence the final word? They get to open and then they get to reply. It's just the way it is. Kells, thank you so much for the YouTube membership. Much appreciated. Cootie Pootie Tootie for the pro bono fund. Thank you so much. Coffee Addiction, thank you for the super sticker. Much appreciated. Angie Torres, how can he bring in new evidence when he rested? I don't think he's bringing new evidence. I think he's planning on using it for rebuttal or for cross. So that's how he'd get it in. What, if any, side quest are we sort of on? The power of suggestion is strong when in shock. It is indeed. Joey Jones Donnelly, Dr. Russell was the first female police officer in my hometown, Malden. Everyone was amazed when word got out she was also going to med school at the same time. Dr. Russell is an incredible badass. So, yeah. Leslie Bowe, thank you so much for the YouTube membership. Blake Caveni, Neurospicy is now my new favorite saying. I wish I could say I made it up, but it's a great saying. Coffee Addiction, thank you for the super sticker. AKA the Cat Lady. Guys, Lucky's asked that we refrain from discussing his wife. Please honor that. I agree. Cat in Virginia, Boston Herald op-ed headline today, plow driver, only honest man in Karen Reed case. Is that serious? Because I agree with it, but yeah. Roland Fernandez, I hope the McAlberts don't decide to rehome Lucky for his testimony. Ooh, that's dark. Wolf Kiara, thank you so much with the 2 white hearts. Great Big Geek, thank you for the 10 gifted memberships. Much appreciated. Witchy Jesse, this entire trial has turned into a sad sideshow. I agree. Kathy, the McAlbert's original plan was to claim John O'Keefe was hit by the snowplow, thus pinning it on this gentle soul. I hope that's not true, because that's gross. Bruce West, miss it in 4 for each of the 4 passes. Oh, you're saying he would have had to have missed it 4 times? Yeah, I just conclude it probably wasn't there. Cat in Virginia, my cousin Lucky. Shirley Lynn, Lally wants us to believe Proctor and Buchanan instead of this man. Even the Commonwealth witnesses say Proctor's reports are trash. We believe Lucky. I agree. God bless Lucky. He's a genuine and honest man. Precious indeed. F.U. Lally. Lucky is a national treasure. So Lucky's bro Michael is chair of the council select board that Chris Albert is part of. He gets harassment from Alberts and testifying can lose his brother. That's no good. Mackenzie Jabali, colorblindness is a thing in my house, husband and son. It could be a thing. I'm a little bit colorblind, but not super colorblind. Mindy Stapleton, my son is colorblind and works in HVAC and has to text me pictures to make sure his wires are the right color. I think that there's actually programs now that will do that for you, where you can just take a picture and it'll identify the color. So, Rainman YYC, I drive a Jeep Wrangler and worked at the factory for a few years. The details of my vehicle are burned into my mind by having watched thousands go by. Fair. Audrey Silva, apparently that interview was in May with the FBI. Proctor was in August. It seems some of this is wrong. Lally can't call out the FBI during this. Yeah, I mean, he could have said something like, you think the FBI got it wrong? But he can't, because they can't mention the FBI. QB, thank you so much for the YouTube membership. Much appreciated. Lori Lenny, a garbage man with an eidetic memory in a certain area of Alberta, regularly helps cops with be on the lookouts and stolen vehicles. These jobs are useful in situations. If you know this guy, I would love to talk to him, because that is amazing. Jennifer Johnson, wasn't Caitlin Albert's boyfriend also a plow driver who testified that he didn't have to be at work until around 3? Why show up at 11:30? I don't know why you would. At that point, the snow wouldn't have been sticking. Studio, how often do lawyers recross after the redirect like Lally did with Lucky? He just asked the same questions from his first cross, way beyond the scope of redirect. If he wanted, could Yannetti have objected and saved Lally from himself? He could have, but sometimes you just let your... There's an old phrase, never interrupt your opponent when they're making a mistake. And I can tell you, I've had moments when the prosecutor was asking my client or one of my witnesses a question, and I was just like, I could object, but I'm not objecting because this question's going to help me. So sometimes you don't interrupt the other side. So, yep. Rev Spins, thank you so much for the 5 gifted memberships. I'm not sure how I'm supposed to pronounce this. Mrs. Jewel, South Florida, I guess. Thank you for seeing me in what I see. Thank you. Silicon 2, lucky justice be done though the heavens fall. Kind of, yeah. It's badass. Megan, aka Meg is autistic. I love your take on this case. Thank you so much. Greg, I just checked. The Boston Herald headline is legit. LMAO. Wow. Wow. Man Bear Pig, Lucky needs to run for a local office after this. And Cat in Virginia says it's a real headline. I am amazed at that, but that is amazing. That's a real Boston Herald headline, though it's an opinion piece. I kind of agree. Okay, let's move on past Lucky onto our next witness, which is Dr. Russell. And you're probably going to want to see this. Like I'm some jerk who's hiding an amazing grandma from you.
I do.
All right, whenever you're ready.
Start
Mr.
reading
Jackson.
cases.
Thank you, Your Honor. Dr. Russell, could you please, in a loud, clear voice, state your name and spell your last name for us?
Hi, Dr. Marie Russell, Russell.
All right, now I am going to skip over her going through her qualifications because her going through her qualifications is basically it's like half an hour. Like she just goes on and on and on about all the things she knows because she can. And it's like a half hour. She starts off as a police and then she's like, being a police officer is too easy. I'm going to go be a doctor. And then being a doctor's too easy. I'm going to become a specialist. I'm going to become an expert in like these particular fields. I'm going to publish this. I'm going to publish that. And he's like, isn't it true you're a member of this particular organization? She's like, I'm a fellow of that organization, which is above member. Thank you very much. Like, she's just like, I have done all the things. I have done all of the, yeah. Oh, Steve A says, there's a reason for my super chat at the beginning. Her listing her qualification took almost as long as Trooper Paul did to earn his. Yeah, just reading her resume is more... So, like, she was just excellent at everything she did, and she's done everything that there is. So, somebody said, like, being a cop was too easy. She went to med school at the same time, or being in med school was too easy. She was a cop at the same time. So, yeah. Okay. Let's jump ahead a whole bunch because her qualifications take all of forever.
Coming to your opinions and conclusions, did you also review a toxicological report
Yes,
and a neurology report, neuropathology report
yes,
as well from the Commonwealth?
yes,
Based on your review of
Yeah, kind
all
of
those
is.
materials, I don't want to know what your opinion or conclusion is yet. But were you able to come to an opinion or conclusion concerning the injuries specifically to John O'Keefe's arm,
Yes.
or his right arm? Were there any documents in furtherance of your review from UC Davis?
Yes.
Did you review those as well?
Objection.
Sustained.
With the court's permission, may we display exhibit 19, please?
Okay.
Doctor, I want to show you a photograph.
The problem is that by the time she's done on Jeopardy, she's just won the show. Like, literally, not just that she won the money, but she actually, by the end of it, she owns Jeopardy. So they'll never let her on because she'll just walk out and, like, the next time she's the host. People are saying mic issues. Okay, let me try to fix that. Okay, let's see. Does that fix it? Did that fix it at all? Are you still getting static? Yeah. Okay, is that better? People are saying, yeah, we're going to go ahead.
Ask you very quickly, have you seen this before?
Yes.
Is this one of a number of photographs that you reviewed in furtherance of your evaluation of this case?
Yes, it is.
I'd like to just focus your attention on this for just a quick second and ask you, does this accurately reflect the wounds or injuries that you saw on John O'Keefe's right arm in coming to your opinions and conclusions?
Yes, it reflects the injuries that I saw in photographs.
All right. Now, based on your review of all of the data that you've talked about, all of the information that you were given and reviewed, what is your opinion or conclusion about how these injuries were sustained?
I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of the injuries.
Could you describe?
So look at what she says. By an animal, possibly a large dog. She doesn't say definitively it's a large dog, just possibly a large dog. And Lally's going to try to pin her into a position that is dumb so that he can attack it. She's not going to fall for it.
Describe for the jurors, please, on what you base that opinion.
Yes. Well, may I use the?
Sure.
Okay, thank you.
She's like, can I use the laser pointer?
Patterns here. There, up on the upper part of the arm, there's parallel lines, and those were inflicted by either teeth or claw marks. So there's a number of patterns that could be teeth or claw mark. And so this is one set right here. This is the one further down, closer to the elbow, is another set of.
And the interesting thing, the really interesting thing about this is not this part. I hope you can see my cursor wiggling around. It's actually this bit, right? This bit and this bit. And the reason why I'm pointing out these three injuries, these three little marks right there, is because the prosecution's theory is that John O'Keefe gets hit and that the tail light breaks and that the edges of the tail light slash John O'Keefe as he gets spun around. But then how do you explain this piece, right? Or these things, right? Those things are really easily explainable by the fact that dogs have upper bitey bits and lower bitey bits. And the upper bits and the lower bits do the bitey thing, right? This is two sets of sharp things moving inwards together and pinching, right? The pinchy. What can a tail light sleeve do? Like, what can a broken tail light thing do? Well, it cannot do the bitey thing. It cannot it cannot bite down on a person. So the question is, how do you get the 2 sets of puncture marks? And I just want to also draw your attention here to these ones. And the reason why I'm doing that is because you see kind of a teardrop shape. A tear, and what I mean by that is that you've got I'm going to embiggen. Now. You've got like a point, and then it gets wider and sort of gives you that teardrop shape, right? I want you to look again at those and see that teardrop shape, right? You can see how there's the point there, and then it's like round, on the other end, right? The way you get that is you've got, let's imagine that like this arm is an arm, and this pointy thing is a dog tooth, right? And so the tooth punctures in and drags, right? The same way a dog bites and pulls, right? Dogs bite, pull. That's how dogs function. Now, dogs get trained to bite, hold, but by sort of nature, they bite, pull. And you get the thin edge of that teardrop at the place where the tooth is coming in, and then the thicker part is the pull, right? That's where you get the sort of pull on that. So when we go back here, we can see bite goes in there, like tooth goes in there, and the pull. Here, tooth goes in, pull. But on the underside, you see a very clear teardrop the other way. Bite goes in, pull upwards. Bite goes in at the bottom, pulls upwards. And so when you've got, like, how does the Lexus, to get the bite pull in 2 different directions on the arm, you'd have to get the Lexus driving really fast one way and then reversing, and the other thing, this is so exactly a dog bite to me. And I mean, I've seen dog bite experts talk about the teardrop shape and the bite pull. This is messed up. Okay.
Parallel marks, again, probably most likely from teeth marks. And the reason I say that is, in addition to the parallel marks up here, down here, there's also little punctate, incomplete puncture marks here, little round marks right there that were inflicted by the actual point of the tooth.
Okay, that was my question. What relevance does that have to your determination that this was likely caused by an animal?
Yes, and I can explain in a moment the various kinds of wounds that animals can inflict. But
now, I don't know if, like, these to me look like claw marks at the edge, but she says they might be snapping things. I'm just like, this is so much a dog bite, right?
Going on with the picture first. So then,
no, we're going to talk about the forensic dentistry pseudoscience and how it differs, because Lally's going to take a run at her with forensic dentistry, and she's going to reject it. And I'm going to talk about just how that run at her is kind of BS. So we're going to talk about that.
And down right at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below some punctate, superficial, round, small abrasions, again representing upper and lower teeth.
Okay, she's given us a very clear explanation. These are upper and lower teeth. These are dog bite marks, or these are bite marks from some kind of animal. And you know what? I'm just going to say, I don't think that there was a bear anywhere around. I don't think there was a cougar anywhere around. I don't think that there was, I don't know, a wolverine or anything like that. Certainly no tigers or lions or hyenas. No monkeys, no gorillas, no crocodiles. Like we can probably assume it's a dog. There's just not that many bitey things that are there. Somebody says wild hog, maybe. Maybe. How does he get into a fight with a wild hog? I mean, I guess that's a weird explanation that maybe he leaves the party. He's like, screw this party. It's full of Alberts and they suck. And walks out onto the front yard and is about to call Karen Reed to say, hey, I'm sorry I was there all night, but they were there. And then suddenly he's just like attacked by a wild pig. And the wild pig attacks him and chews him up. And in trying to get away from the wild pig, he smacks his head against the... I mean, it's still more plausible of a theory than the Lexus. Owl bear. I see owl bear. I see somebody saying there's no hogs in Canton. Okay, I guess we can rule that out. So, you know, yeah, a coyote? I don't know. So, could it have been a wild yote? Maybe. Somebody says man, bear, pig. Yeah. Okay, so that's that. Let's move on to Lally's Cross, because Lally's Cross is something interesting. Somebody says raccoon. I don't. Why would a raccoon go after him? Proctor says at least one cougar in the area. Oh, I read that out before I realized where you were going. Oh.
You are unmuted.
I mean, listen, the things they didn't do in this investigation is a very, very long list. So.
Hey, John.
Sure.
Good afternoon, ma'am.
Good afternoon, sir.
Now, testified that you're certified in emergency medicine, is that correct?
That is correct.
And you're not, nor were you ever certified in forensic medicine, is that correct?
That is correct.
Pathology.
Correct.
And when was the last time that you worked at a coroner's office?
1995 in terms of doing autopsies. Yes.
Now, when was it that you first spoke to anyone from?
Isn't it true that you're really old and you haven't been doing this for a while, and also you're really old? Like, I didn't like that as a beginning. I get that you can, you know, but he just kind of just like, yeah, he just kind of drops that out there.
From defense counsel in regard to your coming in here and testifying today.
May 17th.
Doctor, I am going to ask you to keep your voice up.
Oh, sorry.
Thank you.
May 17th, 2024.
May 17th of this year, is that right?
2024.
So about 6 weeks after this trial began.
I don't know when the trial began.
Now, as far
I actually thought that answer really screws Lally a bit, because here's why Lally's asking, why did you reach out? And he's trying to say that basically she's some interfering clout chaser, that she's just there to get her 5 minutes of fame. And you know what the funny thing is? He's like, about 5 weeks after this trial began, she's like, I got no idea when it began. You know, if she was super clout chasing, if she was super here just for her moments of fame, wouldn't she know when the trial started? Like, she's like, I barely paid any attention to this trial. I just heard there was dog bite stuff and I got it, you know, and like that, I think, yeah. And, you know, like,
as who reached out to who?
I reached out to a district attorney that I worked with with the LA coroner's office.
And then somehow that person put you in touch with Mr. Jackson, is that right?
Yes.
And was that also on May 17th?
She totally looks like the person who's trying to parlay this into a movie role, right? Or like a book deal. Surely she needs help getting published. Yeah, she's been published. She could be published again just by doing more research. Like, yeah. I feel like trying to take a run at her, like, you know, when he's calling like Trooper Paul and Trooper Proctor, like, hey, Dr. Russell, isn't it true you barely even use the C word? How can you be a competent investigator if you're not calling women the C word? Like, okay. Yeah. Okay, moving on.
Some articles that you were asked about in reference to dog bites or canine dog bites in the emergency department. Is that correct?
Yes. Co-authored.
Something that you published or authored or co-authored sometime in the late 1990s. Is that right?
Correct.
And in that instance, you talk about law enforcement dogs and a bite in a hole technique, correct?
Yes.
Now,
okay, so she gives a little sigh here. She gives a little sigh here. Zigzag, we're going to come back to that because that article doesn't disprove the dog bite info at all. We're going to talk about that. This was actually Lally being dishonest and trying to fool you. So we'll come back to that. I've saved that super chat. We'll come back to it.
now, part of the reason in writing that article had to do with sort of the applied forces and the unique spectrum of injuries from those kind of dog bites. Is that correct?
Yes.
And that spectrum of injuries would include deep puncture wounds. Is that right?
They can. Yes.
Severe crush injuries. Is that right?
Correct.
Large tissue avulsions and lacerations. Is that right?
Yes.
Wounds necessitating surgical debridement. Is that right?
Yes.
Bony injuries ranging from cortical violations to displaced fractures. Is that right?
Yes.
Neurovascular damage. Is that right?
Yes.
And other wounds at high risk for infection. Correct?
Correct. But
So he's cherry picking the worst injuries you can get from police dog bites after the police dogs have been trained to cause maximum injury. And he's like, this dog didn't rip John O'Keefe limb from limb. And she's like, yeah, but they're not all the most serious. And I was only looking at the most serious because I was looking at the people who get brought into the emergency room. Like, this injury, if you didn't die afterwards, you'd probably just get healed, like, or you might go and get stitches. But yeah.
we also put a disclaimer in that article.
I'm not asking you about any disclaimer.
Okay.
I'm asking you about what the type of injuries that
He's like, I'm not asking about any disclaimer because the disclaimer completely tanks my argument.
you were looking at. Is that correct?
Yes, but we saw a skewed population.
You skewed population in the study. Is that correct?
What we saw the worst of the worst.
Or no?
Yes.
Skewed population in the study.
I'm sorry, I don't understand the question.
The population.
We skewed the. Did we skew? No, we reported on all the ones that presented to the emergency room for care. However, a lot of dog bites don't present to the emergency room.
And so from the
So she's saying basically the injuries are worse because we're in the emergency room, right? And so you can get bit by a dog and don't have to go to the emergency room. And when she's talking about the possibility for serious injury, it doesn't mean that every injury is the most serious. Like, just because there's a possibility that you will die when you're stabbed doesn't mean that every knife injury is fatal, right? There are less serious knife injuries.
different cases that you report on within that article, are there any of those cases in which there is injuries to just one aspect of one part of the human body for the victims of dog attacks or dog bites in those cases?
There may have been. That's a summary of the 700 cases. More
She's like, probably yes.
than 700 cases.
Yeah, that's exactly it. She doesn't see the simple
Is it
stuff.
normal
She sees the
in
nasty
any kind
stuff.
of animal attack for injuries to occur on just one side of one arm of the person that's being attacked, clawed, or bitten?
There are many people who are bitten or scratched.
I'm asking
Only-
if it's normal, ma'am. That's all
Okay,
I'm asking.
so hold on.
She's allowed to answer the question, and Lally here is specifically trying to interrupt her because he doesn't like the answer she's giving. And he's trying to stop her from answering. He's trying to argue with the witness. It's like, let her answer. And the judge is stepping in to be like, she's got to actually be able to answer the question.
Hold on, Mr. Jackson. Mr. Lally, ask a question, wait for the answer, and then start a next question. Do not interrupt the witness.
I apologize. I don't mean to interrupt, but I'm asking for an answer responsive. What?
You do mean to interrupt. That is exactly what you were doing. Like, just, that is, of course, what you were doing. Yes, you mean to interrupt.
So ask a question and ask it in a manner that you get a responsive answer.
Dr. Russell, is it your testimony that it's normal in an animal attack for injuries to occur on just one side of one arm and nothing else, anywhere else on that person's body?
It can be, yes.
I'm not asking if it can be. I'm asking, is that normal?
I can't say.
It's sustained. You have to ask the question differently.
So from your...
So what he's trying to say is, if it was a dog bite, dog would have bitten everywhere. Show of hands, who here has been bitten by a dog? I'm guessing there's probably a bunch of us who've been bitten by dogs. And the thing is it is absolutely normal to get bites in one spot. I've seen a ton of police dog bites, and they have one bite spot often, or two bite spots next to each other. Lots of people get bitten on one side. The dog is biting what's convenient, right? Dog is like, I'm going to bite the things that are available. And so they're not like, well, I bit one arm. Now I got to go over and like get some variety by biting the other arm. Like,
Observations, you looked at various photographs of Mr. O'Keefe, is that right?
I did.
Did you observe any injuries on any other part of his body that you would attribute to an animal attack, whether it be claw marks or bite marks or anything else?
No.
So nothing on his left arm, correct?
Nothing that identified as a dog bite or
Nothing
scratch.
on his legs, is that correct?
That's correct.
Nothing on his torso, is that correct?
That's correct.
why didn't the dog bite him everywhere? Like, that's not how dogs work. This is, yeah.
Now, you say an animal attack, possibly a large dog, correct?
Yes.
Can you say what type of animal left these marks that you attribute to an animal attack?
Not with 100% certainty, no.
You know, because it could be a dog, it could be a wolf, it could be a hyena, it could be you, Lally.
Can you say where physically Mr. O'Keefe was located when those the animal attack supposedly occurred?
Objection.
Can you say that?
No.
Okay.
How would she be able to tell where? Like, okay.
Can you say when Mr. O'Keefe purportedly sustained these injuries from an animal attack?
Well, to a certain degree, yes. Before it was before death, but not long enough to have a big inflammatory reaction. So yes.
So basically, she says yes, partially, because he was alive when he was bitten, but there's certain things you expect as a wound sort of develops, as it evolves over time, and none of that happened yet. So that leaves us a range. This also, by the way, excludes the possibility that I've seen from some commentators on Twitter who theorized that John O'Keefe got hit by a car and then was subject to some sort of animal predation, like some sort of scavenger. Unless the scavenger was attacking him while he was still alive, no.
So minutes to hours before death.
Minutes to hours before death, but at some point before death, correct?
Yes.
Can you say anything about the breed of dog?
No.
Can you say anything about whether it occurred inside the house, outside?
I mean, she could probably say it's not a Chihuahua, right?
Outside the house, anything like that?
No.
As far as you mentioned some of the different things that you reviewed over the course of your testimony, for the preparation of your testimony, both prior to Tuesday and between Tuesday and today, any of those things contain any forensic reports or phone examinations or anything else related to this case?
Could you repeat that? What kind of examination? Phone?
Phone examinations? Why would she look at a phone examination to tell if the dog was bitey or if these are dog bitey marks?
Materials that you reviewed, whether it be prior, sometime between May 17th and Tuesday, or anything that you reviewed between Tuesday and today, did any of those materials that you reviewed contain any sort of forensic reports or anything beyond the UC days?
Yes, I saw a photograph.
You saw photographs. And to that point, you never actually saw Mr. O'Keefe's body, correct? You just saw photographs?
You didn't actually go visit the... By the time she gets involved in this, the body's already been autopsied and buried. So, no, she didn't, like, dig him up, you weirdo.
That's true.
And with respect to the UC Davis report, as far as canine DNA, are you aware that the results of that were that there was no canine DNA on Mr. O'Keefe, on swabbings that were sent to the UC Davis lab?
I'm going to allow it.
Yes, but there was clothing in between.
Okay, but the swabbings came from the clothing with tears in the clothing in the same area as the injuries, correct?
Okay.
Do you know that or no?
I couldn't tell if they came from the wound or the clothing. I thought that they came from the clothing, but
You couldn't tell by reviewing the report whether or not the swabbings came from clothing or from Mr. O'Keefe's body?
I know the clothing was sent to the laboratory,
You know the clothing was sent to what laboratory?
to the DNA laboratory.
To UC
She's
Davis?
getting a little wandery here. It's not fatal, but it is not great.
Oh, I don't know that. No, I'm sorry.
You are aware that that came back as far as negative for any canine DNA, correct?
That's correct.
Now, as far as the injuries that you observed, your testimony is that both the top teeth of whatever animal this is and the bottom teeth of whatever animal this is both made contact with only the top of Mr. O'Keefe's arm or the posterior of his arm?
Only the top of his arm? Like, I don't understand this question and how they think it makes sense, but he's trying.
Both sets of teeth made contact with certain of those wounds, yes, but not all of them.
But neither the top nor the bottom teeth made any contact that you observed, assuming your issue as far as an animal attack. There's no evidence of any animal attack on the bottom of Mr. O'Keefe's right arm, correct?
I'm not sure.
The problem is the top or the bottom of the arm really depends on the orientation of the arm. So if you imagine an arm put up in a defensive posture like that, as you're defending yourself against a dog that is trying to bite you, then the bottom of the arm is actually exactly where those lower punctures are, right? The bottom of the arm is exactly dependent on the rotation of the arm, and this question is misleading at best. So
What you mean by bottom?
Anterior
Interior? That's correct.
and nothing on.
So basically, they didn't bite the inside of his arm. Okay.
On posterior or the anterior of his left arm,
That is correct.
and nothing on his legs,
That's correct.
nothing on his torso,
Correct.
Going over all that
nothing
again.
on his head. Is that correct?
Correct.
Now, as far as the marks that you did observe that you do attribute to an animal attack, can you even say with certainty whether or not those marks you feel are bite marks versus scratch marks? Do you have any idea which are which?
There may be a combination.
So is that no?
Well, no, I think that the ones that had the linear abrasions above the small round punctate abrasions, I believe that those are bite marks from upper and lower teeth.
Now, you indicated that part of what you had reviewed was a dog bite history for a dog from 34 Fairview Road named Chloe. Is that right?
Yes.
And there were a couple different instances of that dog essentially getting in.
So he's trying to basically bait her into saying that Chloe was the dog that bit John O'Keefe, right? And she's not going to fall for the trap.
Fight with other dogs, correct?
Yes.
And at any point in time, did you see anything in there as far as a dog going after a human in which there was no other dog present?
No.
And there were actually photographs contained within that material of dog bites from that dog, from Chloe, correct?
Yes.
Did any of those dog bites that you saw in those photographs look anything like what you observed in the photos that you saw of Mr. O'Keefe's arm?
No, but. Okay.
That's all, man.
Objection, Your Honor.
He interrupts her.
No, so the answer is no. You can get back up, Mr. Jackson, but the answer to that question is no. Next question.
So she says no, but, and he interrupts. On redirect, he's going to say, hey, I get to answer the rest of that.
Okay.
Oh, we can get closed captioning. I didn't realize that we had that option. Music? There's no music. We can get closed captioning and it's stupid.
So is it your testimony that from reviewing what you reviewed, that what you observe on Mr. O'Keefe's arm is consistent with an animal attack to the exclusion of any other possibilities?
To a degree of reasonable medical certainty, yes.
So as far as any other sort of blunt impact injuries or other manifestations of how those scratches got there, you're saying, nope, had to be an animal attack.
I've seen thousands of wounded.
No, what I'm asking is.
All right. So, Mr. Lally, I'm going.
Mr. Lally, you don't like her answer, but she still gets to answer. You suck.
Going to let the witness answer.
Right.
I've seen thousands of people with injuries to their skin, and from blunt, from sharp, from all different mechanisms. Those injuries did not look like blunt force injuries.
So is your testimony
He did not
the
like that
injuries to
answer.
the arm don't look anything like blunt force injuries that you've seen before. You wouldn't characterize them as that?
That's correct.
And that's based on some photographs and some other materials that you began reviewing
You can hear in Lally's voice, he's not having a great time. So
sometime May 17th, 2024.
Yes, I'm an ER doctor. I need to make a diagnosis quickly when I see something, and I'm trained to do that. That's my specialty.
Are you being asked as an ER doctor to come to a quick conclusion in this case?
No.
I thought this was ridiculous because it's like, oh, you came to such a quick decision. It's like, yeah, it's because it was freaking obvious, dude. Also, Trooper Proctor came to a conclusion of murder with a super brief investigation. I just thought this came off as petty and like snipey and yeah.
But you did anyway.
It's how I'm trained.
Nothing further.
I would have said something along the lines of it's really obvious too, but don't need an extensive amount of time. I missed a timestamp, and I don't have the timestamp, so we gotta go find it. I think it's here. I gotta try to find this because it's the thing I wanted to talk about. I didn't write down the timestamp for this moment.
Doctor, you testified that you had some familiarity with areas of forensic science. You're on some boards, things of that nature. Is that correct?
I think this is
Yes.
And as a result of that, or any other work experience, are you familiar with a NAS report from 2008?
Yeah, that's the one.
Not with that limited information, no.
Are you familiar with like a book that was written in like 2007? It's like, she's like, you're going to have to narrow that down. NAS wrote lots of reports in 2008.
You're not aware of a report issued by the National Association of Forensic Science in 2008, which specifically has a section dealing with.
So I'm going to see you both at sidebar again.
The objection here is you asked her a super vague question, and now you're trying to make it out like she's an idiot for not knowing your super, super vague question. Yeah, I did not love that. Did not love that in the slightest. So yeah, did not love that at all. Debbie W. Check my email. I am checking it. Debbie, I'm not going to pull these up. They're pictures of dog bites. So, yeah, I'm not going to pull them up just because YouTube has rules about pictures of kids. But I see your point about how they are. They got a lot of similarity. I appreciate you sending them to me. I can't pull up. YouTube's got rules about that. Fuzzy mic. Okay. Okay, hopefully that has fixed things, I hope. Okay, so let's keep going here. So they go to sidebar. We skip through the sidebar.
Reports specifically as it applies to forensic odontology.
So could you say that again, Mr. Lally? What's the report?
The National Academy of Sciences 2008 report in relation to the section referring to forensic odontology.
I'm not familiar with that specific report, no.
So then you equally unfamiliar with the representation that is not from the NAS report, that is not a reliable science as far as bite marks are concerned.
Okay, so let's talk about this. This is a issue about bite, like comparing two bites. And so this is not about the evaluation that something is a bite. This is about the evaluation that bite 1 and bite 2 are from the same person or the same animal. And so we've got this. He took a run at her and proved his point. She didn't know about the article that disproved dog bite info. She said she hadn't read it. It doesn't disprove this at all. It doesn't disprove this. What he's attacking here is, and she rejects it. Like, she's going to say, no, that's not true. That report is about matching bite to bite. You know, to be like, hey, and where that usually happens is like, there's a dead body. It's been, somebody's been attacked, and there's a bite mark on that person, and then they go and they arrest a person. They press they press wax onto their teeth, and then they say, yeah, that looks like it's the same bite. Therefore, this person is guilty. That is basically entirely done with humans rather than doggos. And doggos is kind of her interest there. This is entirely playing on an article. I actually think that what he's doing here verges on unethical, because what he's telling the jury is not true. Now, you're never going to be able to get a sanction on the guy because he'll just say, I didn't understand it. That's how I understood it. But this is pulling a fast one. This is shady.
There are certain aspects of bite marks that have been deemed not reliable, and that I believe has to do with saying that this particular person or animal inflicted this particular bite. But that's very specific, and that's what I'm aware of. That recommendation.
And she's correct about that. You can't match bite to bite. Except in some very specific circumstances where it might actually be possible. The specific circumstances are that you need to point to something super unique, right? So let's imagine you've got somebody who's got like 4 missing teeth on one side in one spot. You might be able to say this looks, this guy's got a very unusual bite, and that it matches up to this bite. And therefore, we could exclude lots of people, but not this guy. So when she answers here, she's correct. The question is, does the jury believe her on that? That's a different, that's a different issue. But I think she handles it just fine.
You're not aware of any findings in the NAS report that has led to questioning of the value and scientific objectivity of such evidence?
For specifically identifying a bite mark to an individual that might have inflicted the bite mark, I think that's what that applies to.
Okay, I'm not asking, again, this is a report. Are you familiar with it or are you not familiar?
I'm familiar with a summary or a...
She's like, I've heard of it. I've never actually bothered to read it because we all know what's in it, right? There's plenty of things that you may not have actually read the original thing for, because why the hell would you, right?
Abstract of a report that indicates that forensic odontology is not is deemed not reliable when it comes to that particular narrow aspect of forensic odontology.
And so you're not familiar with it. Also talking about sample data and collection, analyses of these, interpretation and reporting of results. You're not familiar with those areas of the NAS?
Dude, this is... Yeah.
Report as well.
What specifically, do you have a specific question about that, or?
First question was whether or not you're familiar with the report. You indicated that you weren't.
I did not read the report.
From the report.
Mr. Lally,
Sorry.
let the witness answer. One question at a time, one speaker at a time. Doctor, can you answer that question?
Sure. I did not read that report.
Now, you had written some articles that you were asked about.
So he's asking her if he read it, but then he's mischaracterizing the report in a dramatic way.
In reference to dog bites or canine dog bites in the emergency department. Is that correct?
Yes, co-authored.
Something that you published or authored or co-authored. Something.
So I was not super impressed with that, right? I was super not impressed. And I see people saying Ted Bundy. I don't know if Ted Bundy actually is a situation where they shouldn't have admitted the evidence. I don't know about that one. And yeah, odontology has nothing to do with his case or her testimony, and hopefully someone on the jury can point out to the rest of the jurors how dirty and misleading this. I suspect the jury saw it. So I don't know, right? All right. Yeah, and this is the thing, is he tries to specifically bait her into saying that it was Kimmy, you can have a timeout if you're going to throw in all caps. We're not doing that today. Come back when you're ready to, like, not all caps, because we're not doing that. Yeah, it's just it is what it is. So all right, we're going to do a swoop, and then we are going to cover some super chats, and then we're going to go on to our last witness. We got one more. Okay, so super chats. Andrew says Lally's trying to rule out Chloe, not all dogs. The thing is she doesn't say Chloe. She just says it's a dog. Hi, bye password. Off topic, good news. Husband and I were prepping our elderly cat to go into surgery to remove a mass. I made sure we tried antibiotics first. She healed it in 2 weeks and doesn't need surgery. That is excellent, because I remember Potter having surgery, and he had surgery on his ankles, and it kind of sucked, or on his knees, I guess would be the thing there. And oh, Eric, I totally can. And if we're gonna have people doing that, we're just gonna. Oh, I can win that fight. I can tell you that for free. So. Fightbot is activated, so Fightbot can time you all out. It is faster than I am, and Fightbot is now in the chat. So yeah. All right. So yeah, let's go back to the super chats there. I just saw somebody causing trouble. Boston Herald's article says Hoss refreshing he was. That's awesome. Melissa K, thank you so much for the membership. Perry, thank you for the super sticker. And that is a sweet looking cat. Love that cat. Greg says, to quote Colonel Potter from MASH, don't think of me as old, son. Just someone who's seen a lot. Mrs. July, South Florida, I guess. Is that my guess? We need more Dr. Russell and Lucky L indoor lives. Yep. Or in our lives, I'm guessing. Scott Roach, thank you so much for the super sticker. Matilda, good morning from the Netherlands. Thank you so much. Nebraska Jeff, wasn't Higgins trying to bag a cougar at that time? Oh, God. Melanie Haydicky, my son was 5 when attacked by a German Shepherd. His ear was ripped almost entirely and his lower face looked just like that, not a single puncture. I'm sorry to hear that. Jennifer Johnson, she is like the badass Lady Roz from Monsters, Inc. I haven't actually seen Monsters, Inc., believe it or not. Hi by password theory. Chloe was not up to date on rabies vaccine. If that were true, legally, that's a big problem if she bites someone. That's why she got rehomed. I don't know about her vaccinations. Polita, Hearts from Cairo, Egypt. I've never been to Egypt, but I kind of want to. How do you think this style of cross lands with the jury? Seems unnecessarily aggressive. This is not a combative witness. Seems like a lovely Grammy, too. If the jury's thinking that she's like their grandma and that she's sweet and, you know, and they like her, then coming at her hard is going to be... is not going to be fantastic. So I think that that's not great. Tide, I don't know if we need a game or if we need slow mode, but we already have, what is it? Kimmy Love and stuff. Oops, I did it again. Stop spamming caps. Warning. Fightbot will keep managing to go after that. So Fightbot is on the case. I might tune Fightbot's messages to make Fightbot even more aggressive because it's kind of funny. So, all right, next, there we go. Too Short 23, shirt tested but not wounds. Crazy, love your channel. Yep, there was a lot to say about how little they did properly. Philip Martin, does the attorney search lower your opinion of Lally? Yes, I thought that was gross. Nikki Stacks, thank you for the new membership. Thank you. Wendy Wilkinson, thank you for 5 gifted memberships. Much appreciated. Dylan Schultz, have I ever mentioned Ronald Smith, the only Canadian man on U.S. death row? He was condemned for killing 2 men in Montana and remains on death row. Interesting. I did not know that. Maybe I should look that up. Love Dr. Russell, cannot be baited, could have solved. I think so. Allie Lawson, love your commentary. Almost always agree with your analysis. And I don't expect people to always agree with my analysis. I don't always agree with my analysis. Sometimes I have said something and I go back later and I was like, I was wrong. And then I try to go back and say, I was wrong about this. Sometimes it happens. But I usually agree with my analysis because it's my analysis. So nothing wrong with disagreement. As Hogue says, reasonable minds can differ. And yeah. All right, let's move on to our last witness. So our last, oh wait, nope. I wanted to go to, no, I wanted to go to the redirect. Court TV is only showing the,
I'm aware of that.
Did that have any impact in your?
okay.
Are you being asked as an ER doctor to?
Go ahead.
All right, so they're doing the redirect. Redirect is real short, so we're going to cover the redirect.
Concerning the forensic odontology report, the NAS report that Mr. Lally asked you about, what is your understanding about the report as it pertains to identifying individuals who left a bite mark? Explain that to the jury, please.
I believe the report says that that is not reliable as it once was thought to be.
Like a fingerprint identifying a human being.
I'm just going to note, Sherry Botwin, Law and Crime, diagnosed Karen Reed with borderline personality disorder. I think that might actually be defamatory, Kimmy, because it's not ethical to diagnose somebody who you haven't actually been who you haven't actually seen. So all you're saying here is that Sherry Botwin, you're accusing them of doing something unethical. So Also, completely fucking irrelevant, even if true.
DNA identifying a person or a bite mark identifying a person. NAS said, not the bite mark. Doesn't work that way.
That's correct.
Has nothing to do with the pattern of injuries that you've seen 1,000 times from animals, correct?
Correct.
Yep.
You were asked several questions about the injuries that you saw and studied attendant to highly trained canines, police dogs, correct?
Yes.
I don't know who, but
Very different than just a domestic dog that somebody might have as a pet, correct?
Correct.
And the bite injuries are very, very different as well, aren't they?
That is correct.
so member and subscriber, the difference is basically if you want to throw me some money, essentially. So, yep.
To high questions, doesn't work that way.
That's correct.
Has nothing to do with the pattern of injuries that you've seen 1,000 times from animals, correct?
Correct.
So he basically says, hey, let's go back and fix that whole NAS report thing. So, yep.
You were asked several questions about the injuries that you saw and studied attendant to highly trained
Hey, Kristen, good to see you.
canines, police dogs, correct?
Yes.
Very different than just a domestic dog that somebody might have as a pet, correct?
Correct.
And the bite injuries are very, very different as well, aren't they?
That is correct.
So here they're basically saying, because there hasn't actually been any evidence that Chloe is a police dog. And so what he's saying is like the study of the serious injuries from police dogs are because police dogs cause much more serious injuries. Oh, Turtle Boy gave me a shout out. Loves my takes. Okay. I have actually never watched Turtle Boy. I feel bad now. But yeah. The Jackson is noting this is a pet dog. It's not going to do the serious injuries.
You were asked whether or not you were aware, based on UC Davis's report, that there was no canine DNA found on the swabs that were sent to them, correct?
Yes.
Were you also aware that there was pig DNA?
I'd still say it's pretty
Did that have any
unethical
impact in did you analyze that at all, one way or the other?
Although that might be a
Not to
different
any
standard
degree
of
of scientific
ethics.
certainty, no.
But you do know that dogs chew on pig ears sometimes, correct?
Objection.
Stay.
You've reviewed at least a report, if not a series of reports, that indicate that a particular dog has an attack history, correct?
Yes.
In a dog attack on another dog attack where a human stuck a hand in the middle, look anything like these, correct? You remember that question?
I remember a question like
And
that.
you said no, but, and then you were cut off. Remember that?
Yes.
You finish that answer for us.
Yes. So
I'm just going to note it's not Court TV in general. It's just Julie from Court TV. And yeah, others are yeah. Kimmy, if you're going to come in here and troll, you should do it with super chats because if you want me to pull up your stuff, do it with super chats because I'm getting pretty close to just going yeet. Yeah. Your comments are pretty gross, I'm just going to say, because what you're trying to suggest is that everyone with a particular mental health problem is a potential murderer, and that is gross. So, yuck.
animals and dogs in particular can inflict a wide variety of injuries on the skin, from just individual puncture wounds to abrasions where there's a scratching of the skin, to where there's actually a pulling away pulling away of the skin from the underlying tissues, your ripping effect. And so there's a variety of wounds that or patterns that one can see from an animal attack. It depends a lot on the thickness of the skin, the movement of between the victim and the animal, and also the power of the animal and the training of the animal. Yes.
So in other words,
I haven't seen the Microdots graphics. Microdots seems to have some good takes, but I haven't really been following their stuff just because I'm trying to sort of limit things. What time is it in Alberta? It is almost 11. Okay, let's keep going.
words, not all wounds inflicted by a particular animal are going to look exactly the same.
Correct.
Very dynamic situation, isn't it?
Objection.
Sustained.
Doctor, having seen up to 1,000 bites.
I'm trying to fix the. Okay, hopefully this is fixed. Hopefully we're back.
And claw marks on the human body. And based on your review of the entirety of the case file that you reviewed, including the nature and the pattern and consistency of the injuries that you saw on Mr. O'Keefe's right arm, what is your opinion to a reasonable degree of scientific certainty about the nature of those injuries?
Objection.
Sustained.
What is
That's
your
asked
ultimate
and answered.
conclusion and opinion about the injuries that you saw and that you reviewed and that we saw today?
Objection.
Sustained.
Asked and answered.
Can you tell the jurors at the end of the day what is your opinion and conclusion about those injuries?
Objection.
Sustained.
Can we approach?
All right. So basically, he's trying to end on what is your conclusion, and yeah, that he already asked. I don't like them zooming in on the family, but. All right, Kimmy, you had a chance. You're done. Goodbye. Bye. Mike is fuzzy again? What? Oh, God.
All right, jurors, we will take our luncheon break.
All right, so at that point, gone. They don't get to ask that question, and so that was the end of all of it. So, yeah, Kimmy had multiple tries. She just cannot play ball. Just way too much kind of gross discriminatory stuff and gross unethical stuff. And yeah, we're just not doing that. So, bye. We're not going to judge somebody based on a possible mental health diagnosis from somebody who's never actually met. Yeah, that's not cool. Okay, we're going to go on to this guy. One last witness. Oh, and before we do that,
Green.
All right, before we get to Mr. Green, we are going to swoop. Maybe we'll do another swoop. This one. I I love that one just because I thought it was. I actually am kind of proud of that that adventure. We ran that on Roll of Law. That was an adventure, D&D adventure, where the party was a bunch of teddy bears that were animated to go rescue this kid's friend, who turned out to be the dog. So, yeah, that was a fun story. And I've still got the swoop. Who is Jack? Jack was the friend of this kid who they had to rescue from this hag. And so the teddy bears went and rescued the dog who, yeah. I got to run another game. I see motion for a new game. I've got to do that when I can. Yeah. My Jack Russell hates the swoops. I'm sorry. I'm sorry. All right. Was Potter named after Colonel Potter? No, he was named after Harry Potter. And the reason why Potter was named after Harry Potter was because he had a very distinctive lightning bolt pattern on his head when he was a puppy. And then he stopped being a puppy. As he got older, it became kind of an indistinct mark on his forehead and then is barely even visible now. So, yeah. And I think that was on Roll of Law. I think it was Roll of Law that was there. Okay, so let's cover some super chats here. Debbie Kennedy, thank you for the new membership. Amanda Lang, yes, transform it onto Runkle Snarklebot, the most deeply cutting of fight bots. There we go. Sav, have you seen Anne Mess of the Case go this far? This case is a real mess, and normally I'd expect it to just go away before it got here. Kate, maybe, thank you for the YouTube membership. Wendy Wilkinson, I missed that. Andrew Jackson planted a seed regarding the pig DNA on Redirect with Dr. Russell. Yep. He did a great job on the Redirect. I thought that was fantastic. Okay, let's see Dr. Green. Motion to see a picture. I don't know that I have what is it? I don't know that I have a picture of Dr. Green handy. Or sorry, a picture of baby Potter handy. I'll have to go find one. All right. So, Dr. Green.
Where do you live, sir?
I now reside in Coldwater, Michigan.
What do you do?
I own and operate a company called United States Forensics.
And what is United States Forensics?
Sure, we're a digital investigation firm. We have we're licensed in Florida and Michigan, but we do cases across the country.
All right, and again, I'd ask you to keep your voice up only because we have an air conditioner there, and we have jurors behind me.
Okay, I'll do my best, sir.
Yeah, as best you can. Now,
witnesses have a real hard time with the whole keep your voice up. They really struggle with it. Laurie says, way behind. Captain Corey's swoop made me cry balls. It gets to me a little every time. So, yeah.
You are president of that company, sir?
I am.
I didn't end up using the grinder. I ended up using the like a saber saw with a metal cutting bit. So it worked pretty well. Did I find this guy credible? I found this guy to be a little conclusory as opposed to explanatory, but the jury, it'll be up to them. I don't know. We've got a battle of the experts, and yeah, Turtle Boy's quick interview with Dr. Green after the trial showed how kind he is. He seems like a nice guy. He seems like a real sweet guy, but yeah.
In addition to managing the company, what do you do on a day-to-day basis?
Well, I perform the majority of the investigations. I specialize in computer, cell phone, cloud, auto video, metadata media, surveillance systems, things of that nature.
Do you work in conjunction with others?
Certainly.
Describe that, please.
Certainly. Well, we do take cases from individuals. I prefer to take cases from attorneys. So we've also worked with numerous public defenders. We've worked with a federal public defender. We've worked with law enforcement. So quite a variety of clientele.
Civil cases?
Yeah, civil and criminal. I would put it at about 60% criminals, 40% civil.
Okay. And on the criminal side, you've done both law enforcement and defense, correct?
Yeah, most of the law enforcement.
I've seen lots of comparison dog bite pictures, and they all basically say the same thing, which is this looks really like a dog bite. Did I use ear protection? Yes, I did. I actually have some great ear protection. It is this. They do not pay me to advertise or anything like that, but I love these. So Axel, I need to get a referral code from them and shill their stuff.
Some ones, though, have been more geared towards civil. It's when they had perhaps they were party to a suit, and it was just improper for them to use their own experts. So that's where we've provided assistance.
Now, how long have you been involved in the field of data forensics?
Sure. Well, my first case and testimony was 28 years ago. I'm not even sure we called it data forensics back then, but that was 28 years ago. And then about 16 years ago, started the company United States Forensics and been full-time in the industry since that point.
All right. Yeah, you'd mentioned that you'd actually testified for the first time 28 years ago. That would have been 1996, if my math is correct?
That's correct.
You were qualified as an expert witness at that time?
Yes, sir.
In order to have been qualified as an expert witness, you must have had experience before that?
Yeah, it was specifically in computers. We didn't do much with cell phones back then. By about a decade or so in computer IT, networking. We actually built a line of computers, a lot of repairs. So I was pretty deep into computer IT world at that point.
Okay. And you say you formed your company in 2006?
Correct.
And you work full-time, part-time? What's your schedule?
It's been full-time ever since.
Would you describe to the jury, please, your educational background, your training, certifications, etc.?
Why don't we break it down into smaller segments?
Sure.
Okay.
First,
He's like, can you tell us everything you do? And the judge is like, no.
with regard to the training that you've received.
Sure. So that would have to do with Associates of Digital Forensics.
Well, that won't be your education, right? You received an associate's degree in digital forensics?
Correct.
Okay, so why don't we start with education since you did?
Okay. Well, that was part of the work and more or less the formal training to get that degree. The certifications, which again, this all kind of goes hand in hand, but the certification training would be the CCE, which is certified computer examiner from the International Association.
All right, so this guy's got a whole lot of certifications. It just is, right? They collect certifications. I think they're going to give him some grief about, do you specifically have a Cellbrite, certification? He's like, well, no, but I don't need one. All right, let's jump ahead to him talking about Waze.
Mr. Green, what are we looking at?
Okay, so that is the screenshot from the Cellhawk.
And what can you tell us about what you learned from that exhibit?
Well, I'll just use the pointer here, might help. You can see up in this part here, where this is where we apply the filter for 3 feet or less. That'd be the accuracy. And then it actually returns 0 results, meaning all of the data within there had a...
I don't think you can diagnose Karen Reed based on the limited information that is out. I don't think that there's enough to make a diagnosis that is even worth calling a diagnosis. At that point, it's just I'm willing to make stuff up. So,
an accuracy rating higher than that 3 foot. It could be 5 meters or 10 meters, but none of it was granular enough at a 3 foot or less accuracy level.
Okay, and if you had inputted accuracy with...
So I'm just going to say, they're saying 3 foot accuracy. So, how accurate is civilian GPS? So, GPS is accurate to GPS-enabled smartphones are typically accurate to within 15 feet under open sky. Now, open sky is kind of a critical thing there because what is it? Does anyone remember Pokemon Go? That game? What is it? Don't they purposely limit the accuracy? No, they don't purposely limit the accuracy anymore. But if you remember Pokemon Go, I used to play that a bit. The problem is that in my neighborhood, it is like a Pokemon desert. There is precisely nothing where I am. So if I go and try to play Pokemon Go where I live, there is just nothing. I have to walk 15 minutes to get to a gym, and I have to walk 15 minutes to get to an anything. There's just nothing here. You pull it up and you see other people have all this stuff going on their Pokemon Go. And for me, it's just this desert. So, but when I was working at one particular building downtown, there was a particular sort of cluster of Pokemon stuff that was a little bit outside of my area, right? And depending, if the weather was right, I could reach it, even though that stuff was 300 meters away. So, yeah, I would totally, so yeah, I mean, I don't play Pokemon Go just because it kind of sucks. Yeah, the U.S. military could degrade civilian GPS accuracy if they wanted to, but they choose not to. However, the U.S. military has access to better GPS than civilians do. So yeah, 16 feet. So when the prosecution's experts, when the Commonwealth's experts were saying that they were accurate down to 3 feet, that is just not true. That is just not accurate. I got 3 shinies today. I've never gotten a shiny playing Pokemon Go. I gave up on it because I could walk around my neighborhood for an hour and just get nothing. So,
In say 500 feet, what would you find?
Yeah, you would see then a large number of circles, each circle representing the meters that the accuracy would be related to. What's really important to understand, though, is you don't want to look at just the middle of the circle. That accuracy indicates it could be anywhere in the circle. So if you saw one and it encompassed 2 or 3 houses, you could only draw that inference of somewhere in that circle. So it's kind of like how the hurricane, they say don't just look at the cone, right? Because it could be different than that. So
he's basically saying that circle is kind of a prediction area, and you don't know where it's in. And yeah, there are really expensive GPS units that can get within inches of accuracy or whatever. And yeah.
The accuracy, this is Apple's best guess at what the accuracy is. So it could actually be different than that. It's Apple is using a number of services, and they're giving back the best estimation that they can for the accuracy.
So what he's saying is that even that circle that says it's somewhere in this circle may not actually be accurate, because the circle itself is a guess as to how good it is, right? And sometimes it can be difficult to know how much inaccuracy you've got. So yeah.
So we've talked about the location cache data and where it put John O'Keefe's phone in terms of arriving.
Yeah,
at
this is a good.
But was there also Apple Health data on John O'Keefe's phone during that time?
Certainly, yes.
Is Apple Health data generally accepted within the forensic science community as being reliable?
I agree.
The Apple Health data comes from something called HealthKit, but it's integral to the iOS system. So anyone that has an iPhone probably seen Apple Health data, and it's known to have extremely valuable data that the forensic tools work with and present to us. The degree of accuracy, it depends on the type of data that's being pulled out on the artifacts. For example, steps are known to have an accuracy of around 98% on the actual steps occurring.
So
So 98% accuracy sounds great, except the problem is you can actually get like 100 steps that are not actually steps.
Apple Health data returns, for instance, steps of 20 steps within a certain time period. 98% of the time, Apple's going to be right?
That's what studies have shown.
All right. May I approach the witness, Your Honor?
Yes.
The problem is that there's all sorts of things that you can skew that with, right?
You want this back? Okay.
Mr. Green, I've placed another document before you. Do you recognize what that is?
Yes, I do. This is this lists out Apple Health data for that was from John O'Keefe's phone on January 29th, 2022.
All right. That came from the data that you received, the image file of John O'Keefe's phone, correct?
That is correct.
I would offer that, Your Honor.
Mr. Lally?
No objection.
She's asking Mr. Lally just because he's got an opportunity to object, right?
And with the court's permission, may I publish that, Your Honor?
Okay.
Specifically, I'd like to start with page 2, record 2.
Okay.
Hey, Mr.
Yeah,
Green,
focus.
Are you wearing the right glasses to be able to see the scene?
Yeah, I probably need bifocals here. I keep switching glasses, but
Are you able to read what is on the screen? Or if it's easier, you can look on your document in front of you. It's page 2, record 2.
yeah, I think I'm going to have to do that. I can probably still see good enough to do the laser one. I'm sorry, which record is this you're looking at?
Page 2, record number 2.
Okay, yes, I have that in front of me.
Okay. What does record number 2 show on page 2 of John's Apple Health data?
Sure. So this is the number of meters. It's listed as 87.74, and the time is listed between 12:21 and 10 seconds. And there's a milliseconds after that, but I'll just round it off to the second if you don't mind. So 12:21
if you don't mind,
and 10 seconds to 12:24 and 22 seconds.
Okay. And you said that it showed 87 meters traveled during that time period?
Correct.
And with regard to that same time period, 12:21 and 10 seconds and 12:24 and 22 seconds, Please turn to page 5. And Mr. Bates, if you would zoom in on record.
He's going to try for sure. He's going to try. I don't know if the court will allow it based on it being late filed, but we'll see.
Number 2.
I have that.
Okay. What does...
All right. Now, if
number
you're
2
wondering what this means, so was everyone else at this point.
Highlighted on the screen, com.waves.icon.
We're jumping ahead a bit.
What does that mean that we're in right now?
Yeah, well, this is an artifact specifically related to the Waze program.
Waze app.
Yes, sir.
Okay, so we're on to Waze.
Go on.
Okay, and we can see here our entry for the monotonic time, the baseband time, and the display time.
And what did you notice about the relationship of the 3 of those?
Certainly. Well, most noticeable about this, the monotonic is running a little over 3 minutes ahead of the display. So that, I think it's 3 minutes and 1 second, give or take a little. So, in a lot of cases, 3 minutes may not seem like much, but in this case, this struck me as important to. Objection. We'll strike.
Sustained. I'm willing to strike that. Next question.
Okay. I apologize.
That's okay.
You can hand that back to Madam Court Reporter.
Certainly. Thank
And
you.
I'd like to go back to the Apple Health data, Mr. Bates, if you can put that back up. And this was to be page 2, record number 3. And you don't still have that in front of you, do you?
Actually, I do.
You do.
I do.
Page 2, record number 3, sir.
Yes, sir.
What does that show?
All right. Okay, so this is another entry from John O'Keefe's data, cell phone data, and this records 25.46 meters occurring between 12:31:56 and 12:32:16.
Okay. And directing your attention to page 5, record number 3, if you could tell the jury what that shows, and if we can have that displayed as well, Mr. Bates.
Certainly. So this is directly related to the distance, and this is recording 36 steps, and it's the same time period, 12:31:56 to 12:32:16.
Okay, so there's a lot of him going through that. Let's try to see if we can get an actual explanation.
4028, I believe, and it was in a deleted state.
Okay. Now, what would you normally expect to find along with the artifact, sir?
So you'd have the date and time, the URL, which the way the URL presents itself, we know that it's a Google search, but you also see a history of other places that tab has been.
And with this particular artifact, did you learn the full internet history of websites related to that record?
No, that wasn't possible. We were only able to get the one website. I would say,
And I'm sorry,
I'm sorry, go ahead.
I interrupted you. Sorry.
Well, no, so we definitely got the one artifact, the Google search, and we have the time related to it, but we do not know everywhere else that tab had been.
What significance was there to you about the fact that the full internet history related to that record could not be recovered?
Well, I wanted to do a little deeper dive into that, and so I used some various other database specific tools. One was called Belkasoft X, which has an excellent database viewer in it. Sanderson Forensics, which is known to specialize in this type of work, and
ArtX?
I'm sorry.
ArtX?
You saved me. Yes, ArtX, which is a program known in the community for research.
And how did you sort of cross-reference the 3 of those together? How did you use them?
Yeah, so all 3 of those tools, along with Axiom and Cellbrite, which they do have a low-level SQL viewer as well. So I looked at the data with all 5 of those tools, and I found it to be consistent amongst all the tools.
And in addition to using those tools, what else did you do?
So I wanted to get a little more context. One thing with this artifact, it is deleted. And one thing about deleted data, sometimes you get it all back, sometimes you don't, sometimes you get a fragment. Deleted data makes it very difficult to give you the whole picture of what's happening. So
I will disagree a bit with Peter about whether it being a deleted state was conclusive, because deleted state doesn't necessarily mean anything in a practical sense, because sometimes stuff is deleted, but it's not because a person deleted it. It's just because it just got deleted, right? So, yeah. Sometimes stuff is in a deleted state because the computer deleted it, right? As an example of this, let's say I open up a text file, right? That text file is probably going to write some things to the hard drive, right? And then when you close it, it might be that it's like that. It looks like a deleted file, even though I just never actually saved it, right? So, yeah.
This particular case, I want to see what other artifacts were around this time as it related to web history, and particularly this browser database file.
And so what do you compare the 2:27 a.m. search to in order to gain more information?
Exactly.
I'm sorry.
What the information was. So what we found is that when we looked at a particular URL, a particular website that was visited, and then searched using that URL, the browser state database entry is the last entry in all of that. So we could see searches, videos playing. There's an artifact called knowledge C that records the user's activity, but the browser state is the very last entry.
I'm just going to note, this guy is going to be super confusing, right? Because he goes through all of the tech, and most people are not going to follow his explanations. They're going to look at him, they're going to watch him, and then they're going to decide, is this guy more credible? Does this guy feel more experty to me than the other experts, or do I like the other expert? I would love to tell you that the jury watches this and somehow learns to do forensic analysis, and they don't, right? What they do is they hear this guy, they decide if they think he's, if he seems like he knows his stuff, if he seems like he's clear, and then eventually they will just kind of decide either that they don't really believe anybody, or that they believe one of these people. And I would love to tell you, hey, they're going to believe this guy, or hey, they're going to believe Whiffen, or hey, they're going to believe whoever. And I don't think they're I don't know, right? I don't know. I think that they may look at them all of the experts and just say, you know what? All of them suck. All of them are confusing, or all of them are believable. And therefore, I just determined that I don't know what's going on with the tech, and I'm not drawing any conclusions about that. I think that that is a very real possibility here. So let's jump forward a little bit.
22, same day.
I'm sorry. I'm definitely getting a pair of bifocals. I apologize here. I feel a little silly.
By the way, this is the song, or this is the search for It's Raining Men. If you pull up that YouTube link, It's Raining Men. Do I know what type of law the attorneys on the jury practice? I don't. I don't know why they let attorneys on the jury. I'm also going to say this guy has one big advantage and one big disadvantage. His big disadvantage is that sometimes he just basically says, yeah, this is the way it is. And it's very conclusory and sort of simple and whatever else. The big advantage that this guy has, and the big advantage that might, not will, might get the that might actually get the jury to think that this guy is the better witness, is that he says, listen, I used exactly the same phone and exactly the same operating system, and that matters here. because they keep changing things, they do different things or the like, and that might be a huge thing for this.
Yes, yes, on this particular one. So that is just moments before the Google search artifact.
The one that you previously talked about, the Hoslam to die
How long to die in the code, yes.
But all the other history of this particular artifact was before that time, correct?
Correct.
So with regard to what that tells you about when the It's Raining Men was either searched or accessed, was that at, after, or before 227 and 38 seconds?
I'm sorry, can you?
Sustained.
Okay, well, if we say it one more time.
All right, let me try and put it a different way. Given the timestamp of 227 and 38 seconds on January 29th for that Safari suspended state tab with the It's Raining Men, what did that tell you about the timing of when It's Raining Men was accessed by the user?
Yeah, well, so the indications would be that that tab was brought up and then went away from to do another tab. So it can happen less than a second. It doesn't take long to open up a tab and start a new tab. Can be done very quickly.
I'm not really phrasing this the right way to get what I want. What I want is the timing of the interaction with It's Raining Men by the actual iPhone user. When did that happen?
Well, certainly, all the activity that we have is all prior to the recording of this that timestamp.
Unetti's getting a little frustrated.
Right. Now, with regard to this particular example where the browser state DB is the last entry, so
why are we on It's Raining Men? Well, because basically the prosecution's theory is that these other searches basically contaminated somehow this other search, and yeah.
The activity happened before. Was that unique on this phone, or were there many examples of this?
No, I found many examples of this exact behavior.
All right. Now, given your findings in researching these issues and how this user used this
He's
iPhone
got no other
with
way
this
to be.
iOS, do you have an opinion to a reasonable degree of scientific certainty as to the timing of that search for Hoslam to die in cold?
Objection.
Sustained.
Do you have an opinion to a reasonable degree of scientific certainty as to when Hoslam to die in cold was searched?
Objection.
Sustained. I can see you at sidebar.
Thank you.
All right, so you saw that the question was, do you have an opinion to a reasonable degree of scientific certainty as to when that search was done? Objection, sustained. Objection, sustained. Can I see you at sidebar? Okay. What do we see after sidebar?
Do you have an opinion as to the timing of that first search for Hoslam to die in cold?
Yes, I do.
What is that opinion?
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
And what is the basic?
Unetti won that objection. Unetti won that objection, and he got out this statement. That search was made at 2:27 a.m. Hoslam to die in the cold. And I just got to say, if that... if the jury believes that Hoslam to die in the cold search was made at 2:27 a.m., that's the case. That's it. That's over. If the jury believes this, and the jury may not, right? If the jury believes this, then that's it. I don't see how you can convict. If Jen McCabe searched Hoslam to die in the cold on or before 2:27 a.m., right? And the jury may also just find this to be really the easiest thing, because at the end of the day, the jury may say, you know what? The search has 2:27 a.m. stamped on it. 2:27 a.m. seems like the time it would be. We don't believe Lally's witnesses entirely, and 2:27 makes sense. If Jen McCabe searched that at 2:27 a.m., then Jen McCabe had to have known that, that he's out there dying in the cold, perhaps, at 2:27 a.m. And that's before Karen Reed knew it. that ends this, right? If the jury believes that, I would expect to see I'd expect to see a strong acquittal, like and we'll see, right? There may be arguments on the jury. This is the kind of case that could easily have a hung jury, but I'm predicting, my bet is an acquittal. Now it's a bet, right? So, all right.
Just for your opinion.
Again, by how this particular phone operates with that exact operating system and comparing it to other data on that phone and the way it presented it out itself is all consistent with that search happening at or before that time.
And what opinions or conclusions did you reach regarding how, if any?
I'm just going to note as well, if that search is it's a load-bearing search for the Commonwealth, in the sense of if the jury believes that search was made, that I don't see how the Commonwealth could possibly get a conviction. However, if the jury finds that that search was not made at 227, if they find that it was made during that interaction with Karen Reed, there's still lots of basis for acquittal. So this is kind of a one-sided thing, in that if defense has successfully established this in the minds of the jury or leaves them with reasonable doubt, then they got to acquit. But if the jury finds that it was made later, they can still acquit on other bases. So, yeah. Now, we're going to go to another moment here that I think is an interesting moment. Stop zooming in on John. This is cruel.
You are unmuted.
So, Mr. Green, I'm not sure if that question is clear or if you understood it. If it's not, please let me know. But I had asked you from the first recorded call there that was listed as deleted until 8:50 a.m. or so, what percentage of calls were deleted on Jen McKay's phone within that time period?
Yeah, so we found no live data, so 100% of them would have been deleted.
Now, are you aware of the term spontaneous deletion?
So he just said that 100% were deleted. 100% deleted, which certainly sounds like somebody trying to clear out their phone. And so he's asking about spontaneous deletion here. Basically, could it have been deleted some other way?
No, sir. I know what the individual words mean, but in relation to digital forensics, I'm not familiar with that term.
And do you have an opinion as to how those calls would have been deleted from that phone?
Those would have been user deleted.
How many moment?
User deleted. 100% of the calls from the phone deleted. Now you might say, hey, I see somebody saying, hey, people delete search history all the time. Absolutely. But it's still sketchy here, especially because we had Jen McCabe, I think, if I recall correctly, didn't she say that she didn't delete anything? Yeah, that's that one. Yeah, it's it's frightening. So yeah. Okay, let's roll on a little bit more. We're gonna go to Lally, taking a run at the timing. It is getting late. My brain is starting to shut down. So
Did you observe there?
Yes, sir.
Yeah.
Now, is it your interpretation that the timestamp means the search appeared at that time solely based on the naming of the field in the database?
No, sir.
Now, can a wall file contain items that are so new that they're not yet committed to the database?
Yes, sir. That's the purpose of it.
So the wall file holds the newest information until it's merged to the database, including additions, deletions, changes, all of those items, correct?
That is correct.
Now, according to your affidavit, the device was in active use between 2:23 a.m. and 2:31 a.m. And just to be clear, I'm talking about Ms. McCabe's device, correct?
Correct.
And what other searches did you see at that time, and where were they performed?
I'm sorry, can you repeat that? I couldn't quite hear you.
Searches did you observe in that time frame, and where were they?
Prosecutor would probably know because he would have done his research, right? That's the kind of thing I want to know. So,
well, there were a number of websites, including the Rainy Men exhibit that we did. There was Ozone Basketball, I believe. There, Hockermont, Smith. And I can tell you that those, similarly, the last entry with those there is the browser state DB file. It's not at the beginning. It's not at the end. And I have a couple thoughts on why that may be in regards to Ms. Hyde and Ms. Whippen. I'm happy to share those with you.
I'm not asking you anything about that, sir. What
Very
I'm
good.
asking is it
he's like, I'm happy to share that with you. And then he's like, I'm not asking that. It's like, why aren't you asking that? Oh, right, because it would be so damaging to your case. And I see Ale Brun says, good morning from Rome. Love your commentary. And I miss Rome. I've been to Rome twice. I loved it both times. Rome is a wonderful city. I really enjoyed my stays in Italy, generally. So yeah, Italy is a wonderful country. I've only ever had one bad experience with Italy. So, and that was one touristy restaurant.
possible for a change request in the wall to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
I want to answer your question as well as I can. So can you repeat that one more time?
Is it possible for a change request in the wall to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
Venice is great.
A little trouble answering this. So, if I'm understanding correctly, when the wall file gets written to the database, and could that have made the change ending with this deleted record? Is that the question? I'm sorry. I want to answer you. I'm just
That's
a little lost on how you're asking it.
And the question?
Sorry?
Do you not understand the question?
Why don't you move on, Mr. Lally?
Is it possible that the URL field, which has the website name, was updated to the newest search while the timestamp retained the original search? Is that possible?
No, not the way on this particular phone in this particular iOS, and also with the user interacted with it, that it would have been at the 227 or before. The way this very specific iOS was happening, that is consistent with all the other ones that I observed out there on the phone related to specific web searches and activity.
So this is what he keeps coming back to. This is what he keeps sort of returning to, is he basically says this specific operating system. And when he's asked to like, why do these other experts come up with other answers? He doesn't go, hey, these guys are idiots or whatever else. He just says, well, I just look at the I just looked at this specific operating system, and it's different from the operating systems they looked at, so they were looking at the wrong thing. If the jury agrees with him that it matters that it's the exact same operating system, that could be it, right? They could just be like, okay, cool. The only person we trust is the guy who actually did those details, right? So, yeah. Yep. And the problem is that lawyers aren't typically experts. Now, there are some exceptions. There's a lawyer in my area who I refer a lot of the very heavy digital related crimes to, including like bad pictures cases and stuff like that. Why? Because he's got a background in computing and he knows this stuff and can dig into the expert evidence in a way that I can't. On gun stuff, I am better than most people because I can tell you, for instance, what does a sear do, right? Whereas I can tell you that a lot of lawyers in town here in Edmonton, or just Alberta, if you ask them what does a sear do, they wouldn't be able to answer that question. what's a mainspring? Like, what is all these things? So Epic 7000, how can a digital inclined person learn about the law? Either look it up or like go to a law school and buy textbooks. What is a sear? A sear is the part of the firing system that essentially restricts things to firing when the trigger is pulled. That is its function. And it's going to be a very important thing in the Alec Baldwin case, because Alec Baldwin's defense hinges on the notion that there is a defective sear, or at least that's one of their arguments. So, okay.
Possible that the search for How Long to Die in the Cold at 6:24 a.m. was the most recent search completed in the tab.
Okay, well, not in that tab, but I certainly agree with you that there was a second search done at around that time.
Now, is it also possible that the search that you assert took place at 2:27 and 40 seconds in the morning is the same as the search that took place at 6:24:51 a.m. for that same search?
Yeah, that's inconsistent with the actual data I'm seeing on this actual phone with this precise iOS version.
Now, as far as the
So you see, one of the problems here is that the other witnesses like Hyde and Whiffen were able to explain a little bit more about how they got to the conclusion that it was the same thing. Here, he just kind of asserts that that it's the same thing. He says, we assert, it's different searches because I did the search with the right, with the proper version. Have I tried the Joey Moss beer? I have not. I don't know where I'd find the Joey Moss beer. So, yeah. The lawyers have to practice being a bit antagonistic toward adverse witnesses. You're fighting against the instinct to treat strangers with some reverence. Sometimes, yes. So, yeah. I thought that this guy did a pretty good job. Okay, let's wrap this guy up because I think I've sort of summarized him, and now we're going to go to Super Chats. And I saw Crime Sleuthing was asking, did I miss their Super Chat? And I didn't, so I'm pulling it up first. JM told the 911 operator that we just flipped him over, so he was face down. Why has nobody brought that up? It's in the 911 call. I don't know why nobody's brought that up. I think that's interesting because the lividity was on his back. So, yeah. That is a good question. I'm going to have to think a little bit on that. Sin Grace says being spicy / rude because the witness is lying, being evasive is AF or argumentative, I understand. But being rude because the questions are confusingly worded or just because the Commonwealth doesn't like his testimony is not the same. I always tell young lawyers that... what is it? I always tell young lawyers basically that before you should usually start off with a witness gently. You should usually start off with a witness politely. And, you can always go hot later on. Now, the thing is that like once you've gone hostile with the witness, you can't back up and go nice with the witness, right? The other thing is that jurors and judges don't really like to see you taking a shot at a witness until you've earned it. And so usually I like to ask witnesses questions nicely and sort of slowly wean them over to the point where the judge or the jury is going, I think this guy might be full of shit. And when the judge or the jury is at that point where they're going, okay, this person might be full of crap, that's the point where I feel like I can start going hard and doing the aggressive cross. At that point, the judge or the jury already agrees with you. You've earned it before you do it. Lally here, Lally goes hard in situations where I don't feel like he's earned it. And I don't think it works for him, but he tries. All right, let's we'll go through super chats here and then wrap it up. Maverick Angel, yay! Hi from YYC. That's Calgary, and good luck to the Oilers. Thank you so much, Maverick. It's a good bit of Alberta spirit. Iron Rabbit, thank you for the 5 gifted memberships. Much appreciated. Michigan Farm Boy, for our tractors, free GPS is sub-foot or so. Subscriptions for more accuracy can get sub-inch accuracy, but with a ground error correction tower. Interesting. And I mean, I guess that matters for tractors because sometimes those tractors can be like GPS enabled to automatically do farm stuff. I'm not going to pretend I'm a farmer, but I do know that some of those tractors are basically you could have the GPS do a lot of the operating on them. So that is kind of cool. Marsha Barnage, I hope I'm getting that right. I've enjoyed spending the evening with you in chat. Well, I've enjoyed spending it with you. It's fantastic. Wendy Wilkinson, what stuck out for non-tech me is the same iOS used for testing is on the phones. Commonwealth experts didn't. Comparing apples to apples to me is common sense. Maybe that will resonate with the jury too. I think it might. I think that might be what the jury uses to differentiate the experts. It's entirely possible. What we don't know. This guy is super confusing because he doesn't actually know what he's talking about, but he speaks with enough confidence to seem credible. Runkle, you know more about tech and better describe clocks than he did. Fair enough. I actually find that from a lot of tech experts, believe it or not, that a lot of them are experts in operating tools as opposed to experts themselves. So, Michigan Farm Boy, my father was on a jury and was the only gun owner on a gun case. They reportedly all deferred to his opinion on the gun questions involved. This is really common, where you've got one juror who sort of runs the show in the back. Chuchinoko Z, what's more believable, infected virus tabs? I don't think there's any argument about a virus here, so I'm going to rule that out. Cabo August, so glad to see my favorite YouTuber. Enjoy the rest of your weekend. Thank you so much, although I'll probably be at this again tomorrow, although I don't know for certain. Spidley, the other experts substantially disagree with each other and had to do backflips to say this isn't the timestamp you're looking for. They did indeed. Ashley McQuirk, Lally turned into quite a jerk during Cross, in my opinion. A lot of people said that, so yep. Nina Megapint, how is Mr. Runkle still upright after over 6 hours last night, an excellent Friday Night Frenzy, and now giving us this epic recap? We're not worthy. Thank you. Viper Class has just got a Pitbull tattoo while listening in. Lol. Aaron Taylor says, Runkle of the Bailey, have you heard of Joseph Newberger out of Ontario? Great YouTube channel called Not on Record. Focuses on sex assault allegations and family law. Joseph Newberger and I have had some disputes. And I haven't actually watched his channel, so I don't know. It might be great content. It might not. I just know that he briefly blocked me on YouTube because he posted a picture of himself prepping for a hearing. And I could see the client name on the... like in the photo, and I tried to let him know that he needed to take that down, and then he blocked me on Twitter, and then he unblocked me on Twitter and said I wouldn't block you over that, and I was like, yeah. So I don't know if he's a decent guy. I was not impressed by that particular move, but I don't think he likes me. So I've had some people ask me, are you going to do a collab with Joseph Newberger? And I'm like, I don't think it's going to happen. His content might be great. I haven't watched it. Just haven't. So, but that is why I don't think there's going to be a, so yeah, he did, to his credit, eventually take the thing down, and it's not on there anymore, but it was interesting. I gotta say, somebody sends me a pic, somebody sends me something going, hey, you're accidentally leaking a client name. I am 100% sending them a message going, thank you, because that's saving my bacon to spot it. Kate, maybe, thanks for the stream, Runkle. Great to hear everyone's thoughts and questions. Night chat. Good night. Ridgecrest 77. Lally tried to get Karen Reed web lawyer search with web history. Yeah, it was gross. He tried to tender evidence that she searched for a DUI lawyer, and yeah. Jordan L. Have you heard of the Connie report with Not Reading That? It's another great place analyzing. Good try. You got me once. I'm going to pull it up and laugh at it, but good try. Saw that one coming. Almost. All right. So let's wrap this up here. We will Jordan is yeah. All in good fun, but I am going to be watching for you, Jordan. So all right. That's a sort of good place to end. It's a good, ending on a laugh here. And yeah. And by the way, don't go giving Newberger crap. I don't want to have drama or anything. I'm just explaining that we're probably not doing a thing. I'm sure he's a great lawyer, and I'm sure he's a great guy. It's just we kind of had a moment, right? So I'm not trying to throw shit. I'm not telling you not to watch him or anything like that. I'm sure his content's great. He seems to be doing a good job. But yeah, I just want to say, there's no war there or anything. It's just, yeah. Mrs. Squirrel, thanks to Ian, Mods, and chat for being awesome. Thank you. All right. Yeah, everyone has an oops. That is pretty much it. Okay, so what is it? We will roll the outro and see you guys next time. Once I find the outro. I always have trouble with it. Outro, where is the outro? There we go.